two matters of your lordship's day's list, my lord, item number 54 and item number 63. My lord, these matters relates to, my lord, second SLST, my lord, when the petitioners, my lord, because of my absolutely faint gap in bubbling the my lord, OMR sheet in a particular clause, my lord, has been, my lord, cancelled, my lord, and others I have pleaded as well as appended the documents, my lord, have already been allowed in spite of having more gaps in their OMR sheets, my lord. This is the challenge. Before I was just pleading before your lordships that before your lordships, my lord, leaves for the circuit, my lord, kindly takes up these matters, my lord.
I do not know. It will be called on serially. Let's see what happens.
My lord, I am praying for inclusion, my lord, two matters regarding first SLST, my lord. The petitioners are pursuing candidate, my lord, and the portal is not giving permission to apply the petitioners, my lord.
First SLST?
Yes, my lord.
In which? Non-teaching?
Class 5 to 10, my lord.
5 to 10?
Yes.
Upper primary, non-teaching or what?
Non-teaching, my lord.
You do not know. Don't know. What is to be done?
Praying for inclusion, my lord.
Inclusion, no. Come on Monday, let us see.
My lord, two matters, my lord, which has been remanded back by the Honorable Division Bench, my lord, to be heard afresh, my lord. May I pray for inclusion of those?
Well, next year.
With your lordships, kindly may I be permitted to mention a matter for upgradation.
No, please don't mention.
My lord, there is grave urgency. If your lord allows me for 1 minute, I was the president of the managing committee of a school. Before my tenure was expired, I was suspended without giving me a notice. My order for nomination of president was recalled. Thereafter, my lord, there was a new managing committee that was reconstructed, also not adhering with the provisions that were provided, and several guardians have written to the school intimating them about a scam of midday meals being ongoing. Those representations have also not been considered, my lord. This matter is currently in the monthly list, my lord. I'm only praying for an upgradation.
Yes, next month, please come.
Okay, I'm mentioning for serial number 179 contempt matter. The urgency is kindly fixed it at 2 p.m. The urgency is the petitioners
will be taken up at 2 p.m. Don't mention.
May I permit to mention matter relating to second SLST item number 41, my lord. Petitioner applied on SC category, but he's treated as a general category.
All right, the appeal will be taken up. The appeal will be taken up today. Let us see what happens. Tomorrow matters.
Not be taken up.
Tomorrow matters will be taken up. Let us see. You mention. I'll see.
My lord.
Today appeal will be taken up. Go and see what happens before the appeal court.
My lord.
No, madam.
But only one request. There are few matters where there are fresh motions where there were in the in your lordship's list. Some of the matters had not been taken. All the matter have been posted to the monthly list.
Yes.
Fresh motions. No chance.
Yes. You see what is happening.
Every
mention
day only one request. If your lordship takes up the monthly list at least from 2 p.m.
Call the list, please.
May I mention a matter before your lordship? This is the CAN 1 application for addition of the state school board as a party. The petitioner here is the landlord of the premises. The school authority is running the business absolutely without the consent of the landlord. I'm filing the CAN application for the adding the school board as the party.
All right, come next year. All right. Call the list.
My lord, kindly consider my prayer, my lord, as because the matter was heard on 18th November 2025. And I have already mentioned my son name is not appearing in the list. By mistake, Pradut Kumar Pal, instead of Pradut Kumar Das. 25th November, I have mentioned.
It will appear.
My lord. My lord. Likhe dichchi
My lord. My name was omitted in the order.
This is original side matter taking up. Are you there in the original side?
I can fit 6 minutes. But here,
who is your other side? Did you serve?
Yes, yes. But the affidavit of service is there with the record.
Yes.
But Jhuma Chakraborty is appearing. But yesterday I had called her. Now, but the one interesting part, if your lordship kindly turns to the judgment of Justice Rai Chattopadhyay, but at page 50.
Page 66 is impugned?
Impugned, but why I am placing page 50, it's very important. let Justice Chattopadhyay directed, let the page 51, sorry. Page 51, serial number 2. The respondent number 2, Commissioner of School Education Department, Government of West Bengal, is directed to take up the prayer of the writ petitioner for approval and consider the same in the light of the attending facts and circumstances, including the qualifications, so and so. Well, at the office of the commissioner, next page, page 53, took up the issue. Hearing was done. Now, thereafter, the commissioner sent the matter to the DI for final hearing and final order. But that was not the purport of the order of Justice Chattopadhyay. This is number one. The DI took up the hearing at page 66 and dismissed the petition, dismissed the prayer of the petitioner, which is under challenge before your lordship.
Make submission, yes.
Very well. But this is one on technical point. Second is, if your lordship kindly sees, but why I have come before your lordship. But I was appointed in a delegating school as an English teacher in higher secondary department, but on 14th of July 2007. Now,
the ground that has been mentioned, I can see offhand at page 67 that there is no post sanctioned.
I know. I have gone through it. So, kindly give me 2-3 minutes, so that I can place the records.
Let the state come and make their submission.
The state response.
Original site item 6. What is your submission? See, direction, it has been shown to me that the direction was passed by the court for the
51.
Commissioner of School Education to take up the issue. How did the matter go to the DI?
My lord, I am telling your lordship. My lord, there is this particular direction of the Commissioner of School Education to take a decision. My lord, at a relevant point of time, if your lordship kindly gone through the records, my lord, school is unable to show any document in favor of the petitioner or the staffs. Then, my lord, the district inspector of then the Commissioner of School Education directed to grant another opportunity to show all this document to DI, and if he satisfied with the memorandum of 2001, which is applicable for the DA getting school, then after his satisfaction and the rules as set for, if it has been shown to the district inspector of school, then the district inspector of school shall take the decision.
See, the proper thing would have been.
My lord, I am absolutely bound down before your lordship. My lord, if I am being in there, my lord, it would be that the district inspector of school should submit his report before the Commissioner of School Education.
Absolutely.
And the Commissioner of School Education should take a final decision.
Absolutely.
My lord, kindly set aside the order of the DI and sending the matter.
My
lord, kindly. One thing, my lord, kindly ask the DI to place all the record before the Commissioner of School Education, which is annexed herein. If your lordship set aside this order, it will prevent that his findings is bad.
But the person who does not have any jurisdiction to pass the order.
He has the jurisdiction.
No. In terms of the order of Justice Chattopadhyay, he has not.
My lord, may I show the relevant documents to your lordship so that your lordship can.
Yeah, I want to see the court's order.
Yes. Page 50. Page 51.
Yes.
Serial number 2. Serial number 1. The impugned order dated July 26, 2019, set aside. Then, the respondent number 2, being the Commissioner of School Education, is directed to take up the prayer of the petitioner for approval and consider the same in the light of the attending facts and circumstances, including the qualification of the petitioner, which is consisted with the training qualification by B.Ed degree alongside the master degree qualification of him and the present day vacancy position of the school. The said respondent shall pass the reason.
Commissioner of School Education was directed to pass a reason.
I tell your lordship, I was there in the hearing.
My lord, kindly.
The commissioner does not take the hearing. That is the whole difficulty. Their deputies, they are taking the hearing and they are passing the orders. I was there in the hearing.
Please come.
My lord, kindly just 1 or 2 lines and then your lordship can pass that order.
See what the court is thinking of. I'll make it clear so that you can also make submission that whatever documents the petitioner, the school and whoever is there has produced before the DI.
Same will be produced before him.
Let all these be forwarded to the Commissioner of School Education. Let him pass
Yes,
a reasoned order.
Yes,
My lord, in that event, while the Commissioner of School taking the decision, the observation of the DI will kept in abeyance.
Yes.
Not
Not set aside. Yes. Please come.
well, kept in abeyance. The person who does not have any locus standi to pass the order. In terms of the order of the High Court, he is above the High Court.
The order passed by the District Inspector of Schools, Secondary Education, Kolkata, dated 17th November 2025, is impugned in the instant writ petition. Stop. It has been submitted that the aforesaid authority does not have the jurisdiction to pass the order impugned. Stop. The petitioner relies on the order passed by this court on 22nd April 2025 in WPO 409/2019, wherein the court was pleased to direct the Commissioner of School Education
Paragraph 3 also.
to pass a reasoned order as regards the prayer of the petitioner for approval in service. Stop. It appears that the order impugned has been passed by the District Inspector of Schools. Stop. Such was not the direction passed by the court. Stop. The Commissioner of School Education
Let page 58.
the matter for consideration and thereafter forwarded the same to the District Inspector of Schools. And the parties were directed to submit certain records at the time of hearing. Stop. The District Inspector of Schools may act as a fact-finding authority, but the final order ought to have been passed by the Commissioner of School Education in compliance of the direction passed by the court on 22nd April 2025. Stop. It was absolutely improper for the District Inspector of Schools to pass the impugned order. Stop. Next. In view of the above, the order impugned cannot be sustained in the aisle of law. Stop. The District Inspector of Schools is directed to forward all documents and facts before the Commissioner of School Education for arriving at a conclusive decision in the matter, strictly in terms of the direction passed by the court on 22nd April 2025.
But the court did not direct the DI.
The aforesaid exercise shall be concluded at the earliest, but positively within a period of 8 weeks from the date of communication of this order. The writ petition stands disposed of.
But the impugned order is not set aside.
I have mentioned that he could not have passed the order. The facts and documents will go. So this order doesn't have any legs to stand on.
grateful.
Great.
My lord, only one thing, my lord. There are certain allegations against us, my lord. Kindly.
Allegations, DI against allegations are all proper.
Your lordship has not gone into the merits.
I have gone into the merits.
Grateful.
Great. I am led by Miss Jhuma Chakraborty.
Where is she?
I was told that she was online.
Yeah, I do not see. Nobody is there. Can you see? Nobody is there. It's only Gaurav Das. Nobody else.
My friend, before absolute fact, may I forget to mention one ASEAN matter because of that one. My lord, already in Shubhish Sarkar matter gave the age relaxation to the candidate of 2016, my lord. Here, my lord, the petitioner, two petitioners, my lord, two separate. The West Bengal Central School Service Commission not give the age relaxation of 2016, not specifically tainted. They are not specifically, their name not featured in any of the list. They not got appointment. Any of the list, then
Which class?
class 9, 10, and 11, 12.
9, 10, 11.
11, 12, my lord, urgency regarding my lord, 11, 12 is that, my lord. At the time of verification,
It was detected.
detected and rejected.
Huh.
So that's the reason, my lord, and the interview is going on, my lord. It will be kind enough, my lord. If my lord get left tomorrow, anytime, it will not take more than 5 minutes. Already, my lord's order is there, my lord, regarding group C.
All right, tomorrow serve notice upon the commission. Affirmed?
No, not, my lord. Until
Get it affirmed and then give.
okay.
ঠিক আছে, এক্ষুনি এক্ষুনি করে দিস।
কোথায়
Correction. What is the correction?
order is okay, name of the state advocate.
All right. These names have gone down wrongly. The names that are appearing are wrong.
Wrong. Both names.
For the state wrong.
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 These two will go out and these two will come in. Right. Give your names, please.
I've given. This should. I'm good.
Three. 3 minutes I am for the petition. Statement. Relaxation of SLST 2025. Petitioner before your lordships, my lord, not specifically tainted candidates. My lord, at the time of verification, my lord, only on the ground of age relaxation, this candidature has been rejected. Start from the petitioner subject on and from below 15. That's why my lord, I have, my lord, annexed the rejection order. That is at page, my lord, 35.
But in this case, there is a mistake on our part, I must say. You know, in this case, there is a mistake on our part. But he will be allowed, and he has been asked to appear in the interview on 16th, and he should be, he should generate the intimation letter. There's a mistake on our part.
Will you forward a general intimation or notice to the petitioner? Otherwise, how will he get to know?
He can download from the portal itself.
It is there in the portal?
Yes, already we have placed it.
That is his submission.
That it has
Uploaded.
been uploaded in
No, initially we have rejected. That's
Huh.
correct. But that rejection was not correct from our part.
Right. So how will the petitioner get to know that the rejection was a mistake?
No, we are allowing him to appear in the interview.
Then I'll record your submission.
Yes.
Please come. The petitioner was a candidate in the first SLST, 2016.
But he is an untainted appointee. He was there.
All right. She participated in the second SLST 2025 and claims to be an untainted appointee of the 2016 recruitment process. Stop. Her candidature has been rejected on account of overage. She is aggrieved by the same. Stop. Learned Senior Counsel representing the Commission submits upon instruction that the rejection was erroneous. Stop. The Commission will rectify the mistake and permit the petitioner to appear in the interview and the credential verification.
Credential verifications have already been done.
Verification
Oh,
done.
তাহলে verification টা
She
কি
will
হবে?
only appear on 16. Kindly record
Only
that.
interview.
Only interview.
All right.
And for the petitioner subject, below interview date has been fixed on and from 15th.
Yes, your date is 16th.
My date is 16th. Below kindly.
And she has been, and she is scheduled to appear in the interview on 16th December 2025. Step. In view of the submission of the commission that the rejection of the petitioner's candidature was erroneous, accordingly, erroneous, and the commission will permit the petitioner to appear in the interview. Accordingly, no useful purpose will be served by keeping the writ petition pending. Stop. The same stance disposed of.
Subject to Lord's correction, kindly direct the Milord SSC Milord to upload the admit card for appearance in the interview. Otherwise, Milord, I will not Milord. In by this time, if not
We
Milord,
have already uploaded. We have already
if not
uploaded.
if not
We
uploaded,
have already uploaded the intimation letter.
Well,
You can find it out. If you have any difficulties,
The
please contact
intimation
with.
letter and the admit card of the petitioner for appearing in the interview shall be uploaded in the portal of
Only
the
intimation, not admit card.
Admit card is not there.
Sorry, intimation.
intimation.
Only
That's the
intimation.
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 No admit card.
Admit card is there. Sorry, I am sorry. Stand correct.
Intimation will be uploaded in the official website of the commission, if not already done.
Grateful.
Right. Deeply blessed.
Item number 4.
Yes.
Item 4, my lord, for the petitioner, my lord. The petitioner recently applied for in the second SLST as an EWS candidate.
Second SLST.
Yes, madam. EWS candidate, my lord, can you see her form, application form?
Yes, EWS.
The written as EWS, my lord. Also, you got it, my lord?
Yes.
Now, my lord, she appeared in the verification. During verification, she was converted from EWS to general. The ground is, my lord, she obtained EWS certificate after a cut-off date, according to the. But according to the School Service Commission, the cut-off date was 21st of July. But according to, my lord, kindly see their notification, my lord. Subsequently, pursuant to the direction of the Supreme Court, they also reopened the window for making application or correction. Well, can you see the notification version of the notification? In compliance, may I read, madam? In compliance with the solemn order dated such and such, it is hereby notified that the West Bengal Central School Service Commission shall provide a window for 10 days for receiving application. Next, the candidates, next paragraph, the candidates who have already applied and have received admit card need not apply again. So till that date, the portal was open. Even one who did not apply in the previous occasion, they also can apply of that date in terms of this notification. So on 21st July is not the last date. 2nd September was the last date according to this notification. Before that, I obtained my EWS certificate. I obtained my EWS certificate on 12th August.
Yes.
What has this got to do with the EWS? I cannot follow.
Well, they have rejected my candidature as EWS criteria only on the ground.
That you obtained it later on.
I obtained EWS
So where
certificate
is
on.
the error?
Yes, madam.
Where is the error?
They fixed the cutoff date 21st July because
They did not fix. The application date was such that it ended on the 21st of July. The advertisement, the recruitment notice says so.
yes, the recruitment notice said 21st July was the last date for making application. That's why that is the cutoff date. But that not the last date of my, according to my submission, according to this notification, 21st July is not the last date of making application. But 2nd September was the last date of making application. Can you see this notification?
I am not with you.
This notification says so, my lord. Kindly see.
I read the notification in a different way. Please come. The petitioner participated in the second SLST 2025 as EWS candidate. Stop. She has been treated as a general candidate by the commission as she relied upon the certificate under the EWS category, which was obtained after the last date of receiving the applications. Stop. The petitioner is aggrieved by the same. Stop. It has been submitted that though the initial though the last date of filing the application was initially 21st July 2025, but later on the commission provided a window of 10 days for receiving applications by notice dated 22nd August 2025. And accordingly, the last date for filing the application stood extended till 2nd September 2025. Stop. The petitioner obtained the EWS certificate
12th August.
on 12th August 2025. Stop. It has been submitted that the petitioner ought to be treated as EWS candidate. Stop. Paragraph. The recruitment notice published by the commission on 30th May 2025 clearly mentioned the last date of filing the application, which was 14th of July 2025, later extended till 21st July 2025. Stop. The recruitment notice clearly mentioned that that for seeking reservation, certificates issued prior to the last date of filing the application shall be considered. Stop. Paragraph. The petitioner applied within the said date, but she received the EWS certificate later on, that is on 12th of August 2025. Stop. The window which the petitioner is relying upon in terms of the notice of the commission dated 22nd August 2025 was only meant for the candidates from these selected and appointed untainted candidates who were permitted to continue in service till 31st December 2025. Stop. The petitioner cannot avail the benefit of the said window provided by the commission as she already submitted her application within the due date. Stop. Paragraph. If relief is provided to the if the benefit of reservation is provided to the petitioner, then there may be several other candidates who obtained their EWS certificate beyond the cutoff date, who would be deprived the chance to be treated in the reserved category. Stop. The same will perpetrate injustice to them. Stop. Next. In view of the above, the relief prayed for by the petitioner cannot be allowed. The writ petition fails and is hereby dismissed.
Item number 5, sir.
Yes.
But in this matter, I need 7 days time to bring the review chart. That's an evaluation matter.
I am appearing for the petitioner. This is my affidavit of service.
Yes. What is
That
your
is-
prayer?
My lord, at the initial
Microphone, please. Use the
at
microphone.
the initial stage, petitioner was the organizer teacher.
Organizer teacher.
The school was recognized in the on,
No.
on 1st May 2000, and thereafter, my lord, the service of the petitioner was approved on 1st May 2000. The petitioner has served the school authorities 9 years, 9 months. After completion of the 9 years, 9 months service,
But sorry, it is not our
on his
matter. Sorry.
service, my lord, he prayed for pensions according to the death cum
There is
retirement
shortfall.
benefit.
You want
Shortfall,
regularization?
yes, shortfall. My lord, similar circumstances, my lord, same teacher has got, my lord, the pension. Kindly see the order.
Same
passed by
teacher
the-
got pension means?
similar circumstances,
Similar
a teacher who has
circumstances.
completed 9 year, 9 months service by the order of the, my lord, school department, my lord, is getting pension. And this order has been passed in compliance with the order passed in a writ petition. When the Honorable Division Bench also passed the order to comply the, my lord, circular passed by the School Education on 2nd September 2009, where the shortfall of the, my lord, service of the petitioner should be considered in accordance with law, and in accordance with the rules of Finance Department, he is entitled to get minimum pension. This has not been considered, my lord, in this petitioner's case, and the petitioner's, my lord, application has not been considered by the school department.
Give me that notification of the state, the government order.
Kindly see, that is at page 34. Page 35 of the writ petition.
Page 34 is so illegible.
Page 35, next page, page 35, typed copy.
All right.
And my lord, this notification is dealt with by the Honorable Division Bench.
Please come. Did you approach the authority?
Yes, my lord.
You have any
My lord, yes,
instruction?
instruction, my lord, the 3 months delay may be condoned, my lord.
The petitioner, please come. Retired from service on 31st January 2010. After rendering total service of 9 years and 9 months. Stop. There is shortfall of 3 months to complete 10 years of service for entitlement of pension. Stop. Reliance has been placed on the memorandum of the School Education Department, being number 26, page 35, please copy. Dated 2nd February 2009, which mentions that a fraction of a year equal to 3 months and above shall be treated as completed 6 monthly period of service. and reckoned as qualifying service for determining retirement benefits, and the period of service below 3 months will be ignored. Stop. The petitioner prays that he will be covered by the aforesaid memorandum and the terminal benefits of the petitioner be disbursed. Stop. Next. Learned advocate representing the state respondents has obtained instruction from the Assistant Secretary, School Education Department, dated 5th of March 2025, wherein the authority has opined that in the facts and circumstances of the instant case, comma, the shortfall of 3 months period of the petitioner may be condoned as per the existing rules. Paragraph. In view of the above, the instant writ petition stands disposed of by directing the pension sanctioning authority to take necessary steps to condone the 3 months shortfall of the qualifying service period of the petitioner and take necessary consequential steps for releasing the terminal dues of the petitioner. Stop. Next. The authority shall now, as the petitioner retired from service in January 2010, accordingly, the authority shall take urgent necessary steps in the matter and ensure that the petitioner receives all his terminal dues at the earliest, but positively by 31st of March 2026. Disposed, this will be retained with the records. Affidavit of service be written with the records.
Whether the benefit should be given with interest.
With interest, did you raise any prayer earlier? Why did you come to court at such delayed point of time?
No, my lord. 3 writ petitions were moved by the writ petitioner.
3 writ petitions and you did not get the relief?
No.
Why?
My lord, school education passed the order. Kindly see that order. The order that so far as
Shubhrato, as the dues will be received by the petitioner long after his retirement. Accordingly, the same shall be paid along with simple
There is
interest.
such prayer for interest here, my lord.
Simple interest calculated at the rate of 5% per annum on and from the due date till the date of actual payment. This is absolutely illegible.
Item number 6. My lord, 6, my lord.
I'm appearing for the SSC, but only thing the review report we need to another 3-4 days. This is a review matter. Kindly keep it on Tuesday so that we can bring the
Review of
review.
what?
This petition, 43 petitioners are before your lordships, my lord. My lord, they are just shortfall of 1 or 2 marks. My lord, in the provisional answer key, my lord, the answer option was correct according to me, because we have chosen that answer option, so we did not raise any objection. My lord, in the final answer key, my lord, they have changed the answer option, my lord. The very common question, my lord, we have referred 5 references.
Whatever. So the council intends to revert with instructions.
My lord, only one prayer, my lord. Let there be a direction by your lordship to consider the
averment made in the petition, supported by the ISBN numbered book and renowned professors as well as the international authorities in support of my contention at page 15. Starts from page 15.
Please come.
I beg to appear on the statement.
The how many court fees have you paid?
Yes, I have paid full court fees.
Please give. The petitioners participated in the second SLST.
Court fee.
80. Assistant teacher
Assistant teacher for subject geography.
for subject geography. 25. ঠিক আছে. The answers marked by the petitioner in the OMR tallied with the marks, tallied with the answers provided in the preliminary answer key. But the same got changed at the final stage.
And one prayer, my lord.
The petitioners are aggrieved by the same. Stop. They rely upon several study materials in support of the submission that the answers which they had given and the answer of the and the answer published in the preliminary answer key are correct. Stuff. Learned senior counsel representing the commission seeks time to revert with instruction. Stuff. Next. In view of such submission, release on 22nd. 22nd, will it be all right?
He has joined another court, I am told.
22nd.
Only one recording maybe. But in respect of 3 questions, they have awarded marks to all. In this subject,
I was only suggesting. 22nd minute perhaps may spill over till after vacation.
I do not know.
The 22nd, this bench is.
So what? 22nd. Next. After the receipt showing payment of deficit court fees, we retain with the records. Service is also taken on record.
Well, next is similar subject, but with great elaboration, my lord. We have tried our best to present before.
Convinced that the answers are proper.
Yes, my lord. In each and every questions, my lord, we have added 4 to 5 references, all of the national level scholars.
I do not know. See.
Lord, let them consider with our the references and file a report before the lordship, my lord.
Only
can be passed.
same order can only this much.
This is also.
I will request Mr. Alamgir, instead of clubbing 39 petitioners in one, it becomes one petitioner, one series of questions. It becomes easier for us to respond. Kindly visualize,
I understand.
extremely difficult, and with this shortage of time to come up even with a report by 22nd is a Herculean task. I beseech you.
But then since
unemployed youth are told.
Unemployment is not the factor. Thing is, since everything is now computerized,
yes,
maybe not that much of a problem.
Correct. But at the same time, each case is not same. Each petitioner does not have the same problem.
I have followed
39 petitioners has 39 problems. Maybe subject is common.
The questions will
it may. I'm not saying it is.
Also common. The problem is also common. They will they will respond to the question and answer only. They will not respond to each of the petitioners.
No, that is proper. How many questions defective? 3?
12.
12?
Yes, well, kindly, I can place before your lordship all the questions. I can place before your lordship all the questions.
Then he says the preliminary answer key is all right. Then what type of professors are there?
Well, your lordship, kindly consider.
As Mr. Bandyopadhyay submitted before your lordship on the other day.
Item 8.
Your lordship is keeping it on 22nd.
Payment of deficit court fees and
7 will be same as 6.
I'm deeply obliged. I'm deeply obliged.
আটে কি বলছেন আমাদের?
একই হবে তো। মার্কস নেই আনসার। হ্যাঁ।
Mr. Nag, just check up WPA 26316 of 2025. This has been disposed of. There is some problem with the recording of appearances.
এটা তো
It was mentioned.
না
Commission's appearance has been recorded, but now the state's appearance got changed. I do not know. Just inquire. I can see the name of Mr. Shish. Yeah, yes.
Well, we had mentioned, Milord, it was on our instance.
Right.
Our appearances were not there.
Right. And in the corrected order, it has come up Mr. Shishonna Bandyopadhyay, Shondip Dasgupta, Sakib Siddiqui, and Niket Ojha for the state. Are they appearing for the state? Because in the earlier, the other date, they were not there. Some other names are recorded as state councils. Was it wrongly recorded?
I will be candid, Milord, to assess the situation. What has happened is, Milord, as these SLST matters are a bit sensitive and the government is looking after it in a very sensitive matter, Milord, a bunch of advocates have been engaged directly by the department to assist the court.
So,
So at times,
for
there are
state,
overlapping appearances.
no issues?
There is no. There are authorities. They are appearing on authority of the department, Milord. I know it for a fact.
No, it is not there appearing. Previously, two other names were there. Will those names remain?
They are the GP engagement, Milord, but that is not a difficulty.
That will remain.
No, that will remain. That will remain.
এই মামলাতেও তো তাই।
এখানেও তাই, same,
হ্যাঁ,
same.
যদি সন্দীপ কান্তের নাম
This is happening in these matters. There are overlaps at times.
I do not have any problem. I was wondering whether again it will come up for correction.
No, it will not.
This is the reason. Otherwise, how does the court have a problem as to who appears?
But there is no
No issues. All right. Then this will go down.
Six questions.
Because
Six questions. Two questions.
Six questions. Answers. Answer. Wrong. ছখানা question বলছে six না four already. কত চারটে চারটে question. ঘড়িটা
আগে হয়েছে
এই দেশে
yes, 8.
My petition for the state.
What is it?
Four question that have challenged that in the subject English. If it was straightway comes to that page 37, that
Preliminary answer key is all right.
no, I have made objection in
In
respect
the
of one.
preliminary answer key stage.
Yes, in respect of one.
All right.
And so far other is concerned, I have not.
You have not means the answers tallied with your answers,
Yes.
or you did not choose to
In so far
file any
two question is
objection.
concerned, they have given full marks to all.
So you are covered by that?
No, I am challenging that.
You are challenging that.
That they
Okay.
cannot do this.
Right.
And page 37, I have given suggestion, but they have given full marks to all. Yes, they have given full marks to all. To me, this one answer is perfect. So these are my challenge. But let them not file a report on this because they have their experts.
But then the experts have already formed an opinion, and the final answer key has already been published.
No, I have maybe, but I have given some suggestion here along with the books, and so far the marks given to all, that also I have challenged, Milord. The commission has to take a stand, Milord. Then commission has to file a report. Well, the question is, Milord, if it takes up one at page 37, question is change the following statement into a question.
Page 37.
Page 37, question number 43.
In the writ petition, what is this scan?
Scan is for other interveners claiming similar benefits.
Can have service with it? We don't have a can. Nothing.
Other interveners claiming similar relief.
They stand in the same footing as that of the petitioners.
Same question.
How many court fees have been paid?
No, there are 3 petitioners here, 3 or 4.
No,
So far,
the application.
so far interventions are concerned.
Well, it's a good way, Milord, of Milord
Avoiding, no.
avoiding
No,
Milord.
no, avoiding. First only 3 came, and thereafter the
300 comes.
chunk came.
Now kindly see the size of the application and kindly see the
I was wondering. That is the reason I was
application. What a petitioner, bhai?
49.
49.
37 page.
Page 37, question number 43.
43. Where is question 43?
Left hand side column.
Left hand side column. Yes, 43. 57 is mentioned. What is that? Marks to all.
Change the following statement into a question. The statement is nothing could be done. Nothing could be done. Nothing. My answer is what else could be done? Now I'm going to kindly compare with the others. What should have been done? Can't be. What else could be? Could you do? Only one, singular. What have been done? There is no doubt.
I am not an expert in English.
But yes, then somebody.
No, what will be the correct answer? No way.
Some independent expert is not required.
They have their own expert.
Maybe, but I don't mind if the experts gives the right opinion.
I just don't know.
They are questions are being raised against that. Page 33, minute.
$33.
Here, from a poem, this question has been made. Whom does the speaker meet in When's poem, Strange Meeting?
Yes.
Now, page 33, right hand side, clause, question number 6. Now, kindly takes up, along with this, page 52.
No, what is the answer over here?
Correct answer, I have made enemy. I have to find it from the poem.
According to the preliminary answer key, what is the answer?
Both.
Both means?
Friend and enemy.
How can both be friend and enemy?
English is a strange language, and that too a poem. That is why strange meeting.
Figures of speech.
Figures of speech. The curtains.
Yes.
I'm not page 52.
He said something very nice. Now
page 52, Malat.
Yes.
I have taken this suggestion from this page.
Whatever. Please do not read.
Yes, but that's why a part is required to be appointed. I don't mind any independent expert is appointed.
You may not mind. Let the commission file a report. Let us.
No, here we have a thing to say. Not all of the petitioners apparently or the applicants did not challenge 12 questions.
Same question they did not challenge. All different.
Then there is no homogeneity according to us. Objection has not been raised by all. That is also on instructions I am submitting, and it is again I repeat, Herculean for us to respond to 49.
How many questions have they in total objected to?
4.
4. Which are the questions?
In this petition, 4.
Which are petition and the application together?
4.
Which are the questions?
Page 33 I have shown to your lordships.
Each petitioner a question. 49.
Yes. There are 4 questions. There may be so many candidates, but their grievance is the same. Yes?
6, 15 and 43.
But then the answer series booklet and everything will be different, isn't it? Page number say?
I have
page number 33.
33, 34.
33, 34.
and 37.
And there are no preliminary objections from everyone. On,
Even if it is there from one, the answer will be the same.
your lordship will, in that event, instead of 49% and everything, we'll file a report only pertaining to the questions.
Questions,
Yes,
not to the candidates.
I don't differ.
33, question number 6 at the top, right?
6.
And 34, question number?
Now, question at page 33, question number 2 and 6.
Question number 2, the new teacher.
New teacher.
All right.
2,
Question
6,
2 and 6, 34.
15,
34, question number 15.
and 37, question number 36. Sorry, 37, question number 46.
43.
43, yes.
That's the number.
Question number 43.
43, yes.
Kindly indicate in your lordship.
Yes, it will be easy for you all. Please come.
Report
The
the
petitioners and the applicants participated in the recruitment process of second SLST within bracket 80, 2025. They raise objection with regard to the answer published in the final answer key in respect of certain questions. It has been submitted that the answers provided by the expert committee, answers marked by the petitioners are proper and they rely upon several study materials in support of their submission. The particular questions objected to are question numbers 2 and 6 appearing at page 33, question number 15 appearing at page 34, and question number 43 appearing at page 37 of the writ petition. The commission is directed to revert with instruction, written instruction. 22nd.
22nd minute, all these together.
Nothing will happen.
Mr. Singh will be, let it be after the vacation.
What about the court fees? Have you?
So far, intervention is concerned, but I don't require.
That is the strategy.
Stand at the same footing as the petitioners and you do not require.
Well, let them file my report.
Listen, you choose. You can restrict it to the petitioners also. If the questions are the same, what is the use of pressing the can?
But if I want to file my court fees, I don't mind that. But if I want to file court fees, I have to refer a writ petition number and
the writ petition number is there.
Once it is allowed, then he can deposit.
No,
Once the intervention is allowed, he becomes writ petitioner. Then
you
he
can
cannot
pay the entire court fees if he is pressing the application.
Well, I'm unemployed.
49 petitioners in the application and 4 in the writ petition.
The technicalities you have to follow. And if you can continue the writ petition with only the writ petitioners, original ones, choice is yours.
No, I shall.
What? You'll
I shall
fail.
pay. I shall pay.
Everybody wants to stay in the fray. Yes, I'm fighting.
Yes. Why take chances?
Ultimately, in game hall.
Madam, only one thing may I be permitted to say, Milord.
Yes,
Just, Milord, if the preliminary objection have not been raised, your lordship has seen yesterday the cases. Something preliminary objection has been said. Something writ petition in some writ petition, some amendments is there. But in cases where the preliminary objections have not been made, that cases cannot be entertained at all.
Provided the answers differed in the very first stage. If the answer tallied at the preliminary answer stage, then there is no question of filing an objection.
No, therefore, no. That cannot give him a right. Right accrues only after the preliminary objections have been given.
No.
Your lordship is saying in the case where the answer, I have understood. Your lordship is observing that if there is no wrong with the answer in the preliminary level, they have not given the objection.
Yes.
But if
Yes.
in the final
Yes.
level,
Yes. Right.
I have understood. I have understood your system.
The writ petition has been filed by 3 petitioners by depositing only 1 court fees. Stuff. Thereafter, an application for being added as parties, as petitioners in the writ petition, has been filed by 49 applicants. Stuff. As the applicants claim similar relief as that of the petitioners, accordingly, the applicants would be required to deposit the court fees. Stop. Accordingly, the advocate on record of the petitioner, advocate on record of the petitioners is directed to deposit deficit court fees in respect of 49 applicants and 2 writ petitioners. That is 51 persons. By 19th December 2025.
That is only for the
Can is allowed.
Can allow করে দিল।
The department will be required to make the necessary correction in the cause title of the writ petition by including the applicants as added petitioners in the writ petition. Yes.
22nd.
Even the petitioner does not.
Yes. 9.
My lord, I am for the petitioner. My lord, last occasion, your lordship directed me to file a supplementary affidavit annexing the date. My lord, I have intimated. My lord, there is also a delay. My lord, I want to put some medical documents also. If your lordship kindly, my lord, give liberty to file afresh with withdraw with the liberty with documents, because after 3 years it has been filed. After receiving the amount,
you want to withdraw this?
Withdraw with the liberty to file afresh with better document, my lord.
Please come. Learned advocate for the petitioner submits that. Certain very important documents have been missed out at the time of filing the writ petition. Stuff. Prayer has been made to permit the petitioner to withdraw the same with liberty to file fresh petition upon proper and better particulars. Stop. Leave sought for is allowed. Stop. The instant writ petition stands dismissed as not pressed. Stop. It will be open for the petitioner to file fresh writ petition annexing proper and better particulars.
Great. Next is also same.
10. Same order.
Same order. 9 টা কেউ ছিল।
Item number 11.
Item number 11, I am for the petition, and on the last occasion, my lord directed me to pay the requisite court fees. My lord, I have paid this. Here is the receipt.
What is the matter about?
The matter is about, my lord, the petitioner had applied in second SC/ST examination under the category of SC and ST, and thereafter their caste have been wrongly updated into general one, my lord. And they have applied under SC/ST and paid the fees of 200 rupees, which is required for SC and ST. The application started, my lord, on page 25 to 74, my lord.
All right. What happened to that appeal?
Item 10.
It will be taken up?
Taken up.
I'll post this matter tomorrow. All right.
Grateful, my lord.
Check up with the division bench. There is an appeal going on the same issue. Whatever the appeal court decides, we'll follow. Do one thing. You keep this and bring this tomorrow. Order লিখতে হবে না।
Grateful, my lord.
Keep your blessing. Item number 12.
It is that matter, my lord, where, my lord, the petitioner is in a army public school, my lord, private schools, my lord, have challenged the
Rules also.
one portion of the rules. That is, my lord, at secondary level in government or government aided, government sponsored school, calculated on the basis of 2 marks for each year of service in a substantive post as permanent or on contractual basis. That is at page 45. This is the part under challenge in this matter. My lord, before going into this matter, my lord, I just humbly submit, my lord. There are other 55, my lord. It is also the same. So far as this matter is concerned, this is a teacher of Central Board of Secondary Education,
Army Public School.
Army Public School. 55, my lord, it's for the West Bengal Government School, private school. But in this regard, my lord, I would just humbly submit that the judgment of the division bench,
In the matter of
my lord, that is passed recently, my lord, in Orunima Pal.
yes, 16th July 2025.
Yes, my lord. 16 July 2025. Paragraph 30, 34.
Yes,
Did you copy that?
I have a copy here.
Yes, 34, my lord.
Yes.
But what is the object of this experience? This has been defined here. My rule was not challenged before the division bench. The awarding of 10 marks is an weightage to be given on the basis of experience, and it is only expected that in a selection process of this nature and kind, all candidates are required to undergo the rigorous of the selection process in order to select most suitable candidates. Proportionate wage based on the length of service to the extent of 10 marks to be given to such candidate is not arbitrary. The object is to select and appoint experienced teacher. My lord, this is the object. Now, my lord, I just come to the rules once. My lord, your lordship knows, my lord, School Service Commission. My lord, they appoint for government aided and government sponsor school. They don't appoint even for government schools also. So, my lord, here it says at secondary level in a government aided or government sponsored school. Well, I am on the term school. But ওটা কোথায় গেল NCT একটা school. Now, my lord, kindly come at the top in the definition clause of the rule, that is 2Z. 2Z.
Yes.
The words and expressions not defined in these rules, but defined in the Act or in the National Council for Teacher Education Act 1993 shall have the meaning respectively assigned to them in those acts. So, my lord, according to me, subject to correction, the meaning of the word school shall be taken from the National Council for Teacher Education Act. কোথায় গেল? NCT Act. My lord, as per the definition of the school, my lord, I am just bringing the act, my lord, it's my fault. It has 3 parts. One is the government school, one is government aided school, and, my lord,
Sponsored school.
unaided school.
Unaided school.
As per the 1993 Act. But I shall place, my lord. There are 3 parts. So the 1993 Act says there are 3 types of schools, out of which, my lord, 2 types of schools have been included in the rules. So, my lord, there is a class among a subclass. Because 1993 Act, no, 1993. 1993 Act NCTE Act, that is a central act for the entire country, my lord. There, my lord, so far as the definition of the school is concerned, my lord, it says that there are three types of schools. It has been defined. My lord, I'll just place just a few minutes. In this regard, my lord, I have searched, my lord, about the judgments with regard to the Honorable Supreme Court and other high courts. There is no point in this regard till now that whether private school teachers can enjoy experience in this regard. But there is one judgment, my lord, recently passed by the Supreme Court at about 2024 SCC Online SC 53540. There, my lord, rule was not under challenge, or the advertisement was not under challenge. কোথায় গেল? NCT একটা আনা তুমি কি করলে? My lord, here one person, my lord, paragraph 6.
First, tell me whether you are there in a substantive post.
My lord, substantive, I'll come, my lord. Substantive, my lord, this entire rule, this part is under challenge. Substantive means it is approved. It is not a permanent post. It is approved. It does not mean that it is a sanction by any authority. My lord, I'll come to the...
Approved by which authority?
My lord, if it is a private school, it has to be approved by the managing committee. The post cannot be approved by the government. The post cannot be approved by the government. What is substantive, my lord? I have got one judgment of the Supreme Court. It clearly says, my lord, I'll come to that. But my contention is whichever post or whatever may be, the experience must be counted from a recognized school. Because the private schools, my lord, are recognized by the state of West Bengal. No objection is been given. So their standard of education, my lord, is recognized by the state. Maybe the private school is not functioning properly. That's completely a different issue. But their standard of education is recognized by the state. My lord, just kindly come to this one. 2024 SCC Online SC 3540.
This was placed on the last occasion, Monica.
No, my lord.
Chaudhary Charan Singh.
Chaudhary Charan Singh, yes.
Yes, yes, right. This was pointed out.
My lord, just one paragraph, my lord, just I want to show, that is at page, paragraph 22.
Paragraph 6, you said just now.
Paragraph 6, my lord, your lordship, the paragraph 6, what was
I
the
distinguish
contention
the
of the...
judgment from 6 Roman 4 and paragraph 26.
My lord, kindly...
6 Roman 4 kindly sees the fact he was given, HOD had given him a certificate.
Yes, that was I was showing, my lord, HOD has given him the certificate. But the HOD was not authorized to give him the certificate. He was working under private. And my lord, he was under the university concerned. He was working there. But the HOD was not authorized to give him the certificate. In that event, my lord, Supreme Court stated. But the very important point, my lord, paragraph 22 from the 1, 2, 3, 4, 5, 6, 7. Seventh line from the bottom. To our mind, the primary concern is the nature of work performed and whether the work undertaken by the candidate has any nexus with the purported work to be undertaken during the course of regular service. So, my lord, the nature of work which I perform, be it in private school, be it in any other school, whether it will help in the regular service or not, that is the test, my lord, the Supreme Court applied. And my lord, my learned friend was harping on paragraph number 26. Paragraph number 26, I will also place paragraph number 27.
25746. उसमें same point है. 25746.
The true thrust of every selection process ought to be find out and select suitable candidates. My lord, the object what the division men stated. Having experience in the related work and fulfilling other criteria from among eligible candidate and to go ahead with appointing the more meritorious of those found suitable. If in need an individual without having any security of service performs up to the mark and receives commendation from none other than the head of the department, who must have closely watched his or her performance, it would occasion a failure of justice to exclude such individual for no better reason than she did not work on a sanctioned post. My lord, here the head of the department, my lord, I can show. That's why I was referring to paragraph number 6, the submissions of the university. He was not entitled even to give that certificate. The government order was there. My lord, thereafter, my lord, my learned friend would say, indeed, if such be the requirement, it had to be made explicitly clear in the advertisement without any ambiguity, so as not to generate false hope in the minds of individual aspiring for the public employment. My lord, here I say, my lord, the rule or the advertisement was not under challenge. But my lord, paragraph 27, your lordship may see, an underlined current throughout the constitution is the theme of social justice. The preamble as well as Article 38 of the Constitution enjoins upon the state instrumentalist the duty to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic, and political shall inform all the institutions of the national life and endeavor to eliminate inequalities in status, facilities, and opportunities. So, my lord, social justice is also been taken into consideration while passing this order. And my lord, advertisement was not under challenge. What was going on in the court's mind was the nature of job which can help the institution or a regular service in future. This much, what I want to place. And my lord, I would substantive. My lord, I will place what is substantive post that has been defined by the Supreme Court. 1980, Volume 4, SCC 226.
This was also placed on that day. This was probably also placed by Mr. Ahmed that day.
Not in this matter, in some other matter?
Some other matter. But without interrupting my learned friend, those matters are kept on 22nd December. I'm only apprising your lordship so that we don't argue the same point in a piecemeal manner in other matters. I'm apprising my learned friend that it may be taken up with those matters. I can give the WP numbers. We have it.
Same private school.
Same thing. And also, my lord, here he has to overcome page 22 also is fragmented service. And ad hoc and fragmented, both are there. He has to overcome that.
In the rules even.
That also he has to
That
overcome.
is not there in the rules even.
That is the most important part, Miller, in this matter. Leave aside the rule, Miller, whether allow private teachers or not. Can you see the page 22?
Your service period, see page 22.
Yes, my lord.
Dismiss.
Yes, my lord, I admit, my lord, my service period is a continuous service.
In none of these stages, you have completed one complete year.
But actually, renewal in Parmi Public School is made in this way only.
Whatever. I do not say that what you have submitted is improper, but whether this will entitle you to get
My argument, so far as this matter is concerned, my lord, there are other matters where
yes, maybe have better points.
No, but so far as this point is concerned, my lord, what matters is the experience. Admittedly, my lord, I have worked from 3rd April 2019 to 31st March 2020. So
not even a year.
Not even a year, but my lord,
only this much
I
of
gained
experience, and they are giving 2 marks for one completed year.
So from April to March 2020, 2019 April
So
to
they'll catch up from here 2 months, from here 6 months, then 8 months, and then all add up to make 1 year. How will they calculate this 1 year?
Well, total year will be calculated from A to D. A to
and
D.
What about the months?
That will my lord, not be taken into consideration.
Can this be done? One complete year, you get 2 marks. There is nothing to show that you have got
My lord, one
complete
completed
year
3rd
of
April
service.
2019 to 31st March 2020. 3rd April, if it is 1st April, my lord, it will be 1 year.
Not even.
3rd April 2019 to 31st March 2020.
Hmm.
Then, my lord, 21st August 2021 to 31st March 2022. 2 days short. So it is around, my lord, October to March, it will be 6 months.
Then
Then
when you
9th
get
May,
this 1 year, how do they calculate this 1 year?
my lord, the first A is 1 year,
No, it won't be.
B is 6 months.
A will not be 1 year.
31st
Part of
April 2019 to 31st March 2020.
April. It's
3rd April. So
13th April.
3 days short. 3 days short.
Then what can be done? Where do you get? There may be matters where the teachers are there for years together. In that case, we will see. But is this a good case where you can get the
Well,
benefit?
rule does not say so. The rule says it will be calculated per year 0.2.
Where is
2
the
marks.
year?
Well, to calculating from A to D, my lord, it comes a year.
No.
And also, my lord, if they are aggrieved by the rules and the interplay of the rules, they could have come earlier also. The rules were there.
Challenge. It has submitted that the rules is under challenge.
It could have been done, my lord, in June also, my lord. People coming late, my lord, your lordship has dismissed petitions, my lord. If I can persuade your lordship, my lord, with
Kindly
those
see the
orders.
rule.
But he has accepted the rule. He has accepted the rule, and thereafter he appeared in the examination.
I'm aggrieved by the rules.
No.
My
Yeah,
lord,
you
kindly
have
see 45.
without having any demur, he appeared in the examination. Now he is coming. He is taking a chance.
How many marks did you score in the?
My lord, kindly see the rules. It says on the basis of 2 marks for each year of service.
Yes. Where is this each year? This I cannot find.
My lord, each my lord will be calculated from A to D. A to D.
That is not each year.
My lord, A to 3rd
I'll
April to
post this
31st March
later on.
2020.
Doesn't matter. I'll post this later on. Come.
This.
Acha, whether the petitioner would be entitled to marks on account of prior teaching experience in second SLST 80 2025 is to be decided. Stop. These matters are fixed when?
22nd of
Released on 22nd December.
But item number 55. 55, my lord. Those are permanent posts in private.
All right. As and when the matters are taken up, orders will be
Let
posted.
that also be taken up on that. Because the point will be decided. Huh?
13.
Judgment hai na, chip.
Same over here, prior teaching experience.
Contractual teacher, part-time contractual teacher.
Where is the petitioner? Yes.
The commission was supposed to revert back with instructions that part-time teacher in a government-sponsored school. That we have affirmed a supplementary affidavit from where we can also demonstrate that at least one of us was appointed as an examiner by the board even to examine Madhyamik answer scripts. Apart from that, Millard, we have enclosed
How
our
many days did you teach?
from the year 2013. 2020 লিখে তো 2020 আরে এটা তো সেদিনকে সার্টিফিকেট ইস্যু করছে অ্যাপয়েন্টমেন্ট লেটার ওটা ইয়ারলি
Come ready. 22nd. Come ready. 22nd. Don't record an order. List নিচে 22nd. List নিচে 22nd লিখে দেবেন.
ফাইল দাও ফাইলটা দাও my lord part-time teacher claiming 10 marks my lord your lordship can hear
22nd. All right, 22nd. 1 year total completed. 1 year.
It's a government sponsored part-time teacher continuous service. They are saying part-time teacher not substantive, they will not get.
No, but then is the service continuous?
Yes, service continuous.
In this matter, Guru was appearing for the state.
I'm not passing any order today.
15 months. 59. ठीक है 22 हाँ
None appears on behalf of the petitioner at the time of call. Released on 5th January. Yes. 16, same order. 17 also same order. All right. 18 also same order. 19 also same order. 20 same. 21 same. For 22.
22 তারপর সেম সেম না এখানে জয়েন করছি দেরি করে এক্সপেরিয়েন্স
Which item number is called?
Anamika Roy.
My lord, 15 to 23. I'm praying for short passover. I'm late by 21, 22 ka amar. 21, 15 to 21.
I am posting it on the 5th of January.
5th of January.
And I'm recording nobody was present.
I'm praying for short passover. I'm led by MD Sarwar Jahan. He is engaged in code number.
Order record করতে হবে না 5th January থাকুক
5th January.
5th January.
22nd এটা 21 পর্যন্ত হলো
My lord, 23 to 26 same.
As and when it is called on, just wait.
My lord, I'm for the petitioner.
22?
Yes, my lord.
Yes.
My lord, the petitioner has been appointed in a delay period due to the fault of the respondent authorities because someone else has been given appointment in the place of the petitioner. So that is why, my lord, she is praying for the full marks of prior teaching experience, as it is the respondent authorities' fault and not any fault of or her own part. So in support of that, I have got some judgments, my lord. (2015) 14 SCC 335.
Says rejected, Lord.
— 15, 14,
22 is going on.
Yes. Kindly see the paragraph 14.
Which one? Which judgment?
2015 14 SCC 335.
Paragraph
14.
All right.
May I place before your lordship?
But this is in respect of promotion.
My lord, but this can be interpreted in case of this petitioner, my lord.
Yes.
In normal circumstances, when retrospective promotions is affected, all benefits flowing therefrom, including monetary benefits, must be extended to an employee who has been denied promotion earlier. As the monetary benefits, so and so. In state of Kerala versus E.K. Vaskaran Pillai, this court held that principle of no work, no pay cannot be accepted as a rule of thumb, and the matter will have to be considered on a case-to-case basis. My lord, paragraph 14 also, paragraph 15 also, my lord. We are conscious that even in the absence of statutory provision, normal rule is no work, no pay. In appropriate cases, a court of law may take into account all the facts in the entirety and pass an appropriate order in consonance with law. The principle of no work, no pay would not be attracted where the respondents were in fault in not considering the case of the appellant.
So if you have a case for payment, then that is different. What about experience?
My lord, here it says that full benefits, including monetary benefits.
Monetary benefits you can get.
Other
How
benefits.
can you get the experience without teaching?
My lord, other benefits as well. Kindly see the second order, that is the judgment passed by Honorable Division Bench of this court, and which where it has been considered. The Supreme Court judgment I have placed is it has been considered. Paragraph 9. On the other hand, the counsel for the state submits that there are other judgments which run counter to this proposition for the simple reason that the person who had not worked, not discharged the duties attached to this post, not entitled to receive any amount or
Don't go by the amount.
Or otherwise, my lord. Amount or otherwise means other.
It may be promotion.
My lord,
it may be granting notional benefits. There are various.
The fact remains same that no work. There has been no work rendered, no duties has been rendered. The fact remains same. And in the petitioner's case also the fact is same that she had not been able to render her duties due to the respondent's fault, my lord.
I am still not convinced.
My lord, the judgments have been so far saying that even if on the part of there has been no work has been rendered, no duties have been rendered, then also if the respondents are at fault.
Would you like to do some more research, or I'll pass order today?
Then, my lord, kindly give me some more time.
Some more time? All right. The petitioner relies on the judgment delivered by the Honorable Supreme Court in the matter of Ramesh Kumar, this Union of India and others, reported in 2015, 14 SCC 335, and the order passed by the Honorable Division Bench of this court on 25th February 2025 in FMA 1235 of 2024 with IA number CAN 1 of 2024. In support of the submission that the petitioner ought to be given the benefit of prior teaching experience, as the petitioner was no way responsible for the delay in her appointment. Stop paragraph. The court is not convinced with the submission made by the petitioner. Stop. To allow the learned advocate for the petitioner to come ready with further research work, released on 22nd December.
Grateful, my lord.
I have passed a judgment just a few days back.
I am aware of that, but that is, my lord, no work, no experience. That judgment is of 1996, my lord.
It is a very recent judgment which has been taken into consideration, where it is specifically mentioned for notional benefits, for promotion and everything, you can get that. But without working, you cannot get experience. This is exactly the phrase that has been used. All right?
And I will do some more.
Please.
Thank you. Grateful, my lord.
23, 24, 25, 26. My lord, in 20.
Yeah.
I'm not recording an order. ওগুলো কি রেকর্ড করা হয়েছে? লিস্ট বলে কিছু হয়নি তো? কিছু হয়নি তো 15 থেকে 21? No order recorded. It will come in the monthly list of January.
272564
My lord, in item 22, my lord, affidavit of service kindly taken.
Yes, give. 22 affidavit of service written with the records.
Grateful, my lord.
27, my lord, I appear for the petitioner, my lord. Here, my lord, the petitioner participated in the second SLST, my lord. My petitioner is possessing, my lord, EWS certificate, my lord. But pursuant to the notification which was issued on 22nd September, my lord, I could not upload the same, my lord. But although my lord, the
When did
certificate,
you obtain the
my 23rd
certificate?
September.
You obtained it on 23rd September. How will you get the benefit of that?
But on 23rd September, my lord, since my lord, the opportunity was granted by notification dated 22nd September, notification was issued to upload the certificate to update the EWS the category, my lord.
What does updating mean?
But to get the benefit of the EWS
Yes.
certificate, my lord.
According to the rules, you are required to possess the certificate prior to the last date of closing the application.
Yes,
Application closed in July. You got it in September. Why will the benefit be granted to you?
Since my lord, prior to that, there was no notification, my lord.
Which notification?
To update, my lord, the same, my lord. And I have
The
obtained.
application, suppose that window had not been given, what would have happened? Nothing.
Yes.
So, dismissed. Please come. The petitioner participated in the recruitment process of assistant teachers conducted by the West Bengal Central School Service Commission in the year 2025. Stop. She participated. She seeks reservation under the EWS category. Stop. The certificate relied upon by the petitioner,
page 45,
in support of such reservation was issued on 23rd of September 2025. The last date of submitting the application was 21st July 2025. The petitioner did not possess any certificate on that date. Stop. The recruitment notice clearly mentioned that for being considered in the reserved category, certificates issued by the competent authorities of only the government of West Bengal on or before the last date of receiving the online applications shall be treated as valid. Step. Admittedly, on the day of admittedly, the petitioner failed to procure the EWS certificate on or before the last date of receiving the online application. Step. The petitioner relies on the notice, addendum notice, published by the Commission on 30th July 2025 in support of the not 30th, not 22nd of 5th August 25 and 22nd September 2025 in support of the submission that the Commission granted last opportunity to the candidates to update their categories, and accordingly the Commission ought to take into consideration the EWS certificate relied upon by the petitioner issued on 23rd September 2025. Step. The court is not convinced with the submission made by the petitioner. Step. The recruitment notice relying on which the applications were called for mentioned a particular date within which the certificate ought to have been obtained by the candidate for seeking reservation. Stop. Permitting a candidate to update or edit the caste category or their category for reservation does not imply that certificates issued beyond the prescribed period can be relied upon. Stop. Next. If such relief is extended to the petitioner, comma, then several other candidates who received their certificate after the last date will be deprived of the opportunity to be treated as reserved category candidate. Stop. The same will amount to discrimination and injustice caused to them. Stop. In view of the above, no relief can be granted to the petitioner in the instant case. The writ petition fails and is hereby dismissed.
Get one.
Uh, 28, my lord, I am for the petition, my lord. On the last occasion, my lord was pleased to direct the commission an instruction, my lord. Here, my lord, the petitioner, my lord, that did not mark the appropriate option in the OMR sheet against the category, my lord, booklet series. Although the petitioner mentioned the corresponding series at the designated space in the OMR, as a result of which our OMR were not assessed. Whereas, my lord, I have relied upon a document of some candidates who also made mistakes in filling up the OMR. Their candidature were considered and marks have been awarded. Considering the same, my lord was pleased to take the commission to obtain instruction.
Yes. My lord, kindly see first that his booklet, that's page 28. That's a OMR.
Yes.
My lord, that is the round sign has not been given there. That is only the booklet series. Right. My lord, now your lordships will find the documents which he has given. My lord, 20, 20, 30 your lordships will find. This another one, he has also not given. 32 also not given. Now, my lord, kindly this supplementary affidavit which has been filed. That's page 6.
এই সাপ্লিমেন্টারি কপি দাদাকে দিয়েছো? দিয়েছি।
His allegation is that some persons have not given that marks. It's a round marks, round sign. But your lordships will find from that the roll number has been given.
I did not follow. Page 6, what you showed? Supplementary?
He roll in the roll number.
Yes.
But they committed, according to him, they committed mistake by bubbling it. But the roll number has been given. Therefore, we can reconcile this from the roll number. Then the similarly venue code. Venue code can be reconciled. And subject code has also been given. Booklet has been given. Now, apart from booklet, the things, one can reconcile. Our motto is not to reject everyone. If I can reconcile, I can reconcile. That here booklet is given there. Booklet, if it is not there, then it cannot be reconciled.
The booklet
But
is
we are-
mentioned in page 28.
No, page 28, if I do it, then I have to tamper his booklet. That I cannot do it.
I did not follow. Why tamper?
But if I make a bubble there,
No, why will you
then
make a bubble? You will not make. The booklet series is there. But then possibly commission is
booklet
right.
series is there.
I think the commission is right.
My lord, kindly appreciate. Kindly see, my lord, supplementary fee page 6, my lord.
Yes.
My lord, the roll number, my lord. But the roll number of the OMR, my lord, is separated into several blocks, separate blocks. Each block consists of one digit. My lord, the candidate is required to mention the particular, my lord, the digit at the designated space at the top of the block, my lord, and they are required to, my lord, mark the corresponding, my lord, the circle just below it. Here, my lord, kindly see, my lord, against the 9th block, my lord, digit 2, my lord, they have marked, the candidate has marked against the circle with 1, not 2, my lord. 9th block, my lord, 2, 2, 1, 2, 5, 7, 6, 1, 2, my lord. 2 is numerical block, my lord, is 2, my lord. Against that, my lord, the candidate has marked, my lord, the circle with, my lord, 1, not, my lord, the circle with numerical 2. Despite that, my lord, the OMR has been, my lord, the assessed and marked has been awarded.
They say that they could reconcile it.
But in my case also, my lord,
in your case, it could not have been done. You know the reason why? What does OMR mean? It's optical marking, right? Till you bubble it, the computer or the machine will not record anything.
But
you have not bubbled anything. You're writing, the computer cannot see. The computer will only see the bubbling part, the shading.
Yes,
where
madam.
the shading is not there.
But I have also annexed, my lord, page 8, my lord, of the supplementary affidavit, my lord. That
Yes.
can also, my lord, he did
Bubbling is not there.
not there, my lord. 84.
Yes, and they have
Assessed mark and assessed OMR has been assessed and marked has been out.
84 page 8 of the supplementary. Please check.
Well, that is a subject code. Can you see?
Yes.
That subject code also can be reconciled.
The apart from the booklet series, everything can be reconciled.
Yes. Because
how is it
one
so?
is the roll number is there. What is this? Venue is there. And
No, venue is not important. Thing is,
no,
the you can
roll number is important.
yes,
The roll,
the roll number
the
is
roll number-
important. The petitioner's
Right.
roll number is there. It is only the
Uh-huh.
booklet series which has not been bubbled. And the
Yes.
subject code in page 8 has not been bubbled in the supplementary. You could find out which subject code the candidate mentioned.
But from the roll number, we can ascertain the subject code. But from the roll number, it is correct. Then the accepting booklet, others 4 can be ascertained.
Anyway, I am not inclined. Please come. The petitioner, how many are there? Petitioners participated in the recruitment process for appointment as assistant teachers. Stop. Assistant teachers conducted by the West Bengal Central School Service Commission in SLST 2. Stop. They are aggrieved as their
But-
OMR
But petitioner is an
answer.
untainted teacher, my lord.
What can the court do? How can this mistake be done? Try to understand.
Kindly let them consider, my lord, only.
How will they consider?
But kindly
Is there any scope for consideration? Where is Mr. Bandyopadhyay? Is there any scope for consideration? They say they are untainted teachers.
Mr. Bhattacharya is there.
No scope. I do not know. See,
If we mark
Maybe
the
at least
among the booklet,
judicially, I cannot. If they do it on their own, that is up to them. I won't stand in the way.
Your Lordship's order passed on 18th of November in WP 25765.
there was no document, my lord.
That also there is an order that without this circling and everything.
Yes, I do not know. But then it is up to you whether you can consider or
No,
not.
no,
Initially, I cannot pass order.
Instructions, no.
Then OMR mismatch will be
They
there.
are aggrieved as their OMR answer sheet has not been assessed, as they inadvertently failed to shade their booklet series. Stop. A supplementary affidavit has been filed by the petitioners in support of the submission that, in respect of candidates who did not shade the subject code and erroneously shaded their roll number, দিয়ে শুরু করলাম। Their answer scripts have been assessed. Stop. Prayer has been made to direct the commission to assess their OMR answer sheet relying on the booklet series marked by them. Okay, answer sheet alphabetically marked by them. Stop. Paragraph. Learned senior counsel representing the commission submits that that as the roll number of the candidate who erroneously bubbled the space meant for roll number and the subject code হচ্ছে না, বলুন আর একবার। হ্যাঁ, ঠিক আছে। Can be reconciled accordingly. The OMR sheets of the said candidates have been assessed. Stop. Booklet series is different in respect of each candidate, and the candidate was mandatorily required to shade the booklet series. Stop. By merely mentioning the booklet series alphabetically will not be enough for assessment of the OMR answer sheet. Stop. Paragraph. I have heard the submission made on behalf of both the parties. Stop. The OMR answer sheet of the petitioners is annexed to the writ petition. The instruction mentioned in bold letters at the top of the OMR sheet clearly lay down that items in serial numbers 1 to 5 should be properly filled and shaded in appropriate boxes and circles, otherwise the OMR sheet cannot be evaluated and shall be treated as cancelled. Evaluated or, not and. The said instruction is mentioned in English language and vernacular. Stop. The candidate, for reasons best known, though mentioned the booklet series in alphabet, but failed to shade the proper circle. Stop. As the booklet series differs from candidate to candidate, accordingly, the commission cannot be directed to reconsider assessment of the answer sheet. Stop. The petitioner appears to have been negligent at the time of filling up the OMR answer sheet. Stop. The court does not find any error on the part of the commission in not assessing the answer sheet of the petitioners. Stop. In view of the above, no relief can be granted to the petitioners in the instant case. The writ petition fails and is hereby dismissed.
Get one.
Please issue what happened the petition. Or kindly
My lord,
state what-
in this matter, my lord, in this matter, I have just now received the report. I have not gone through the just 2 minutes back. Can I take it, my lord, next week, my lord, Tuesday? This is evaluation.
But I have just, my lord, one request to your lordships, my lord, subject to, my lord, sanction from my learned seniors here. My lord, now, my lord, we are in the process of, my lord, the verification of the documents. If I just could, my lord, because here, my lord, lordship kindly remembers this incumbent, my lord, had specifically, my lord, made the objection during the time when she was supposed to make the objection of the answer scripts and the questions. So even in spite of that, my lord, that was not taken care of. Lord, may I pray before your lordships till the next date of hearing, my lord, if this candidature of this incumbent, my lord, is subject to the result of this writ petition, because this may happen that I may be, because I am anyways, my lord, through. But it
So
may
can I
happen.
take it tomorrow? I will just read it and I will place my submission. Can I
Right,
take it tomorrow?
Not today.
Grateful, grateful. And may I just get a copy of this, because lordship's earlier direction, my lord, is directed upon the commission, my lord, so that they circulate the copy on me as well.
Give a copy. At least if the hard copy is not there, a soft copy
Well,
will also
I
do.
am sending it to a soft copy
Yes, yes.
to my junior. They will hand it over.
Yes,
Just
yes.
now it has come to me.
Grateful, man.
Item 30 also not identical issue, my lord.
Which identical?
29.
Item 30.
They are supposed to file a report, my lord.
Ritu Chakraborty.
Not Ritu Chakraborty. 30.
আমরা তো ঋতু চক্রবর্তীই করলাম
29.
Item 30.
Can you see
My lord, I have to check up. I have to check up. Kindly give me to this time.
Not today.
The report has not yet come. Report has not yet reached.
Get it ready and bring it tomorrow, and soft copy be
No,
served upon the
just one.
petitioner.
Give me 1 second. Just give me 1 second. Take it tomorrow. Possibly he is right. Take it tomorrow.
All right, tomorrow.
For the petitioner, my lord, there is a question model answer mismatch. There was a direction to file report. I have not yet received the report. It's regarding the subject Sanskrit. I have not received the report yet.
Will this be taken up tomorrow or today?
Tomorrow. I will give the
Tomorrow.
report.
Very well. May I get a copy?
Yes.
Mr. Bhattacharya, I am sending you the soft copy. You just send it to him.
Very well.
Very well.
Soft copy, kindly take it.
Yes.
Not today.
পরেরটা এটা আমাদের না 34 বোধ হয় কপি দিয়ে দিলাম 30 কত রাখলে 32
My lord, Mr. Anindo Bose is another court is saying this, my lord. Kindly.
Who is he appearing for?
Anindo Bose.
Who is he appearing for?
I am for petitioner. We are for petitioner.
Are you sure he is appearing?
He is appearing.
What is the name of the petitioner?
Hey.
32.
I don't see his name. Somebody else's name is there. There is here also a written report is to be disclosed. Come tomorrow. They'll prepare a report and it will be circulated.
I'm for the petitioner, my lord, led by Mr. Firdaus Samim. He is engaged into courtroom number 14, my lord. For that reason, I'm praying for a not today.
Not today?
Yes.
Not today.
Lord, I'm for the petitioner. This is the report is due. This report, the model answer question due. I have not yet received the report. That is only I have only one humble submission, my lord. Due to inadvertence, my lord, one candidate's preliminary objection has been left out. So I prepared a supplementary affidavit. I already served upon the commission. My lord, can let it be taken into record.
Nutrition subject yesterday your lordship has dismissed it.
No, the question to question different. Question to question, there are 6 questions here. Question to question, it may differ. Their decision may differ. So a report is required to be considered, my lord.
All right, supplementary affidavit filed on behalf of the petitioner number 8 in court today is
Have you got the report?
Yes, I had already.
Mr. Lairi, have you got the report?
No, sir. I have not yet received.
Okay, I'm giving it.
Very well, ma'am. Tomorrow?
A report was directed to be filed by the commission. Let the report be prepared and served upon the learned advocate for the petitioner, released on 22nd.
My lord, tomorrow your lordship is keeping the other matters.
There is no supplementary in those other matters.
No, it is just a document. It was missed out. It has given, my lord. I have already handed over. I keeps it tomorrow, my lord. It will not change the nature and character of the matter.
If it has to be kept tomorrow, then supplementary, you take it back. I'm not passing any order.
Very well. I'm taking it back. Kindly keeps it tomorrow.
Not today.
Yes. Very well. Tomorrow I'll stop. Grateful. Tomorrow.
35.
35, no one is there. 35 and 36.
35 and 36?
No one's there.
No one is there. But then you are supposed to take instruction. Commission.
We have taken the instructions. He has not filled up the application form properly.
Do one thing, none for the petitioner. Released on 22nd. 36 is same.
I'm for the petition. I'm challenging the list allegedly, and my lord, the court fees has been paid. Lordship may kindly takes up, I'm challenging the list where, my lord, the names of my clients have been published, claiming them to be the tainted candidates. Now, my lord, Lordship may kindly takes up the judgment of the Supreme Court, which I have provided singly, not annexed. On the last occasion, it might be there in your Lordship's records. The
Which judgment?
Boishaki.
Boishaki.
Boishaki. Now, my lord, parts and bits of the judgment are being placed before your Lordship without placing the entirety. I'll be praying that kindly allows me to place the paragraphs, some paragraphs, with the context. First, my lord, only to just, my lord, by this time, my lord, it has, my lord, your Lordship might have, my lord, the entire judgment might have been seen many times. It is by heart by now, but still, kindly sees the internal page 9, paragraph 363, which has been shown many times, but still also I am showing to your Lordship. নয় নম্বর এইখানে না, জাজমেন্টটা বের কর, বৈশাখে না লাগানো, আলাদা করে লাগানো থাকলে একই জিনিস 10 বার করে দেখাতো। পেজ 9, ইন্টারনাল পেজ 9, আমি ইন্টারনাল পেজ দেখাচ্ছি। OMR sheets available in the 3 hard disks, if not already done, or such portion not done, must be uploaded in the website of SCC forthwith and made available to the public for viewing. These are, my lord, the OMR sheets of the, because your Lordship was not there in the first round of litigation, may I just indicate to your Lordship what were the facts? Because I am there from, my lord, round 1. These are the OMR sheets which have been obtained from a person known as Pankaj Bansal, who was one of the employees of NISA, being the outside agency which was, my lord, engaged for scanning and evaluation of the OMR sheets. This particular gentleman was in Noida. The OMR sheets were may I, Lordship may not look, it was there. May I kindly takes, my lord, I'll not, my lord, tell anything which is not in the facts. He was in Noida. Certain hard disks were recovered from him, and, my lord, a certificate under 65B was taken from him, which was the subject matter of challenge before the Honorable Supreme Court. Now it is subject matter before the trial, because Pankaj Bansal has to come and depose and support 65B. If he doesn't come, depose, support 65B, that these hard disks will not be proved. This hard disk, as of today, on record, has not been authenticated by any FSL, any agency, but the Honorable Supreme Court has taken this hard disk into account in view of the fact that this hard disk was discovered during the CBI proceedings, and the Commission has not disputed. So therefore, these OMR sheets are being taken into account. And from those OMR sheets, it apparently transferred that the person's marks which have been given were in mismatch with the marks which were there in the SSC server, which was not recovered from there. It was from SSC server. We were given appointment on the basis of SSC server, and these are the marks of the OMR sheets, evaluated OMR sheets. Now, my lord, on the first round of litigation, it was shown to the court only there were several blank OMR sheets. I will show how many blank OMR sheets are there. But the petitioners before your Lordship, I have annexed the OMR sheets, are persons who have filled up the entire OMR sheets. So they are not the blank OMR sheet candidates. That is why it comes to our second paragraph. Persons who have been appointed outside the panel. These are the persons appointed outside the panel. These are persons, they did not even participate in the recruitment process. Yesterday, Mr. Shamim was doing one matter where your Lordship has been pleased to direct the board to produce that affidavit which was filed before the Honorable Justice Gangabadhyay, from where the main conflict began. Because at that relevant point of time, that was also taken into account by the Honorable Supreme Court. The SSC said that we have given appointments to certain persons, but the board came and said that no. we don't have the recommendation letters, but we have given appointment. So these are the persons who are outside the panel persons. After expiry of the panel are also the persons who have been appointed post expiry of the panel, and in these appointments there are heavy criticism from BAC committee in respect of 9 and in respect of group D and group C, and my lord, criticism from the CBI and subsequently the finding of the Honorable Supreme Court at paragraph 31, which says that this is illegal, and it is being argued before a lordship that though it is illegal, we are not tainted. But I'll try to substantiate that also. And also those who submitted blank OMRs. How many blank OMRs were submitted? I will show from the CBI's record. That will also show that these are the numbers of blank OMRs. So we do not fall in either of these categories. But obtained appointment must return all remuneration and benefits received by them to the state exchequer along with interest calculated at 12% per annum from the such and such answer. Now, my lord, kindly comes to the paragraph where the Honorable Supreme Court has set out the table while recording the submissions of the board. Kindly comes to paragraph 23, internal page 28. Whether this was at all taken into account, accepted by the Honorable Supreme Court, that is subject matter before your lordship interpretation. Paragraph 23, page 28. WBSSC has been candid enough to admit 1. Rank jumping, that is to say candidates having lower rank were preferred over those having higher rank. These are persons who had participated but rank jumped. Out of panel appointments, these is candidates who are not in the panel of shortlisting candidates have been recommended and appointed. So these are the persons who did not even participate in the recruitment process. 3. Candidates who were not recommended by SSC were appointed by the board. These are also persons who have not participated. Manipulation of OMR scores, however, there is a discrepancy in both the number of candidates and their corresponding percentage where such irregularities have been identified. So there is discrepancy. What are the discrepancies? Now the Supreme Court is trying to, in the judgment, show what are the discrepancies. Impugned judgments refers to the following statistical report submitted by the WBSSC before the High Court. So this was submitted before the Honorable Division Bench. This is not the final one. Here, my lord, lordship would say this only one line, that is OMR issue 783-1741 comes to 2524. Now, in the written submission filed on behalf of the SSC in court, 2 tables have been furnished. Table 1 pertains to candidates who either jump rank or were appointed despite not being in the panel. Their details as under such and such. Now, Mala kindly takes into account for this case, group D and group C and D, table 1, rank jump candidates 132, 237, total is 463. Out of panel but still appointed. Out of panel but still appointed. So rank jump and out of panel combine is 381 and 608. This my lord comes to 989. Kindly, my lord, I have worked out. Table is there. Table 2 furnished by the SSC is for candidates who were appointed by manipulating OMR sheets. Table 2 is under. Now, my lord, number of candidates with alleged OMR score mismatch as per CBI image 592 in respect of 910, 907 in respect of 1112, group C, group D 3481, 2823. Now, this yesterday your lordship was pleased to direct in one matter for publication of 952. These were the candidates in respect of whom, my lord, there was mismatch, but all of these candidates were not appointed. Kindly see the next column. 808 candidates were appointed. This 952 had already been published in the year 2022. Most probably the date is in November 2022. This was challenged by some of the teachers saying that we should be added in the party respondent, which was rejected by the Honorable Justice Gangobadhyay. Out of that, first round of appeal went to Honorable, disposed of by the division bench, presided over by Honorable Justice Subrata Talukdar. Thereafter, to Supreme Court, disposed of by the Honorable Justice Onruddha Bose. That is first round. So this was published. Your Worship has yesterday directed republication. 907, this was only the names have been published, not the OMR sheets. Lordship will be taking up several matters subsequently. So therefore, I'm just, though this is, I'm in now appearing Group C, Group D, but still I am giving the backdrop. Why only the names were published? Because when this order was passed by the Honorable Justice Gangobadhyay, as his Lordship then was, some of the 11-12 candidates, because I did the matter, had preferred the application, rejected, went to the division bench. Order was originally passed. I have the orders. If your Lordship wants, I can show. Order was originally passed for publication of the OMR sheets as well as the names, father's name, everything. Though I have a issue with regard to publication of father's name and whether it is at all to be construed as particulars within the meaning, within the word particulars. But there was a direction. That direction was challenged by us before the Honorable Division Bench, presided over by the Honorable Justice Somen Sen. His Lordship was, the Honorable Division Bench was pleased to direct that since you are similarly circumstanced with the 9-10 candidates, there will be no publication, but one publication in respect of the names were upheld. That was upheld in the Supreme Court also, but the OMR sheets have till date of 11-12 not been published. Now, Group C, 34812823, and the Honorable Supreme Court has taken up this number and has not taken up the, now since the Honorable Supreme, everything is closed now, we cannot argue all these things. 7821911 are the persons who were out of panel but appointed. In another written submission, so therefore Supreme Court is recording how there is a discrepancy. These are not the sacrosanct figures. As it is being placed before a Lordship, these are not the sacrosanct figures. These are the process of recording, that this was before the Honorable Division Bench, this is before me, and thereafter the findings. In another written submission filed on behalf of the WBSSC, this in this court, it is claimed that on further verification, the following details of candidates either rank jump or were appointed despite not being in the panel came to light. So therefore, now the figures were again recalculated, and this is the list. Persons identified as tainted in the category of rank jump and out of panel but appointed. Rank jump is such and such. Kindly see now Group C and Group D, 132 and 237 is 369. I have calculated this, and 249 and 371. This is out of panel but still appointed. So rank jump and out of panel. This figure would be 369 plus 620 is 998. 989. Previous page also the same number is there. So these are the ingredients now which has been taken into account for publication of the list which is challenged before a Lordship. My contention of challenge is that the list is not right. It includes persons who are not supposed to be, that is us, who are not supposed to be in the list, excludes persons who are supposed to be in the list, being the expiring panel candidates. Now, my lord, this list kindly now takes into account, my lord, the calculation. So if we take 132,237, it comes to 369. 249,371 comes to 620. And thereafter, the details of candidates who were appointed by manipulation of OMR sheet is under. Now, my lord, I will only take the OMR issue recommended by candidates. Next, B. Number of candidates identified by CBI appointed appointed and not appointed. This includes appointed and not appointed. 3481, which is not been taken into account and has not been published. 782 plus 1741 comes to 2523. If my lord adds 369, 620 and 2523, it comes to 3512, which is the figure of the impugned list. Kindly, if your lordship, would your lordship see or lordship remembers? Yes, by now. So, while my lord publishing this list, my lord, the expiry panel has not been taken into account. OMR mismatch has been taken into account, and which in my humble submission is erroneous in view of the findings of the Honorable Supreme Court subsequently, which has been again, my lord, clarified and reiterated by the Honorable Division Bench. That is my point, one of points. WBSSC claim that 57 Group C and 170 Group D, I have annexed the list also, with OMR mismatch were not recommended but appointed. However, their names also figure in the list of candidates appointed through rank jumping and out of panel. So therefore, these candidates would also come under rank jump and out of panel, because these are the candidates who didn't even participate. They were taken in, and what was the mechanism adopted, that also I'll show, to show that these are the real culprits who had come subsequently, did not even participate, and who had taken the advantage of the SSC forming a committee. SSC not forming a committee, state government forming a committee under the guidance of the Joint Secretary of the state government in the month of November. And previously also there was, these things were continuing, because after we are the persons who have been appointed in the first round of this counseling, first and second round. Everything started from third round onwards. Third, fourth, fifth, it went down to sixth round. So therefore, this committee, which has been heavily criticized by the BAC committee, saying that this particular committee, which was formed under the chairmanship of the Joint Secretary of the Government of West Bengal, was not appropriate, as the government cannot regulate the recruitment process. And this committee, the persons who were there in this particular committee, have been, my lord, made accused persons in the criminal proceedings, as, my lord, opined by the Honorable Justice BAC committee. That is also there in a judgment, which I'll show to your lordship if your lordship has not come across. Judgment dated 15th May 2022, passed by the Honorable Justice Talukdar and the Honorable Justice Supratim Bhattacharya. Oh, Justice Anandamoy. So therefore, there also, because that is the only judgment from where we know what BAC committee has come to, my lord, conclusions. Because as of today, the BAC committee report has not been published. When the state government went to the Honorable Supreme Court and the Honorable Supreme Court, because it was not published there, the Supreme Court was of the view that the judgment itself quotes BAC committee report in extenso, so therefore there is no further use of publication. So that is the only judgment from where your lordship can see what were the findings. At least we can. Your lordship can always call for the record. At least we can see. So that is also, that I'll also place before lordship relevant parts, so that lordship subsequently, my lord, takes up. WBSSC claims, so yes. However, their names also figured in the list of candidates appointed through rank jump and out of panel. WBSSC admits that 1498 is the calculation, addition of this out of panel but still appointed. 1498 out of panel were illegally appointed. This is 1498 is addition of this table A, out of panel but still appointed. It comes to 1498. 126 candidates were involved in rank jumping. This is the calculation of this 926 candidates. This has been taken, 926. 4091 candidates were recommended despite OMR mismatch. 4091 is the addition which is there in table B itself. 4091. Thus, excluding 239 candidates, 239 candidates is 57 plus 170, that who fall under both OMR mismatch and other irregularities, illegalities. West Bengal's such and such acknowledged that 6276 illegal appointments were made. At this stage, so these are the submissions which have been recorded by the Honorable Supreme Court. At this stage, we would like to refer to the affidavit dated such and such filed on behalf of the Commission before the High Court at Calcutta, where SCC stated, I will not place the entire, but it was stated that relevant parties, which has, my lord, weighed. However, as the CBI has not disclosed the details with regard to the said illegal appointments detected by them to the chairman or to the secretary of the commission is not in a position to state the number of such illegal recommendations and stroke or furnish the details of such candidates. So therefore, the commission took the stand before the Honorable Supreme Court that we don't have any definite data. So that is the reason the Honorable Supreme Court was of the view that then the entire selections should go. Because if this is the stand of the commission that CBI has not given to me, I cannot disclose. This was the last stand. WBSSC, however, submits that the affidavit dated 27/9/2022 was filed before they had access to the status reports of the CBI and the data details gathered pursuant to their investigation, including the scanned mirror copies of the OMR sheets. The data which has now come to light shows segregation of meritorious candidates from those appointed illegally. Therefore, SSC argues that the entire selection process should not be annulled. So this was the submissions. Till here are the submissions. Now, paragraph 28. We may have accepted this argument if SSC had original physical OMR sheets or mirror copies of the OMR sheets. So therefore, the Honorable Supreme Court did not take into account whatever that these calculations were given. But one of my point contention is that even as of today, the SSC is proceeding on basis as if these data were sacrosanct. These data are not sacrosanct. That is my point that I'm trying to substantiate. However, WBSSC accepts that they do not have any physical OMR sheets as they were destroyed in terms of Rule 21 of the classes 11-12, which required, which the rule is quoted. This was the stand. Admittedly, the OMR sheets for the candidates who had applied for non-teaching Group C/D were also destroyed. The reliance placed on Rule 21 of the Commission to justify the destruction of OMR sheet is misplaced, as Rule 21 applies to assistant teachers of 9, 10, 11, 12, not to non-teaching Group C, Group D staffs, because Rule 21 was there in 2016 rules. Group D, Group C, Group D were being proceeded on the basis of 2009 rules. In 2009 rules, there was no provision for destruction of OMR sheets. In 2021 rules, 2016 rule, Rule 21 was there. The Commission had adopted a policy decision on the analogy of the Rule 21. They had destroyed the OMR sheets of Group D, Group C too. That was not accepted by the Honorable Supreme Court, saying that there was no provision. And another difference on provision is that in teachers, there was no provision for extension of panel, life of panel. In Group C, Group D, there was a provision for extension of panel, but it has to be by way of a written order showing reasons. In the entire 11,000 pages before the Honorable Supreme Court, the compilation, there was nothing, no document to show that in fact Group D, Group C panels were although they were proceeding with the counseling, but there was no order showing. I'll show that rule also. There was no order saying the reasons as to why it is expedient for the Commission to extend the period of life of the panel. As Rule 21 applies to such and such, it is acknowledged that the chairman of the Commission in the letter dated such and instructed destruction of the OMR sheets relating to 2016 selection process for assistant teachers, Group D, Group C. Moreover, given that the recruitment process was ongoing even after 1 year validity period of the panel, there is no justification for destruction of OMR sheets. It is apparent that the time period fixed in Rule 21 was coinciding with the time period specified for validity of the panel. Further, the commission did not maintain mirror copies of the OMR sheets in their records. Thus, the destruction of the physical OMR sheets and the failure to maintain mirror images of OMR sheets are significant factors which were rightly taken into consideration by the High Court. We concur. So, destruction but continuation without any extension. On the basis of this, paragraph 31 comes, which has been placed, I know, innumerable times, but I have taken this opportunity to place it in continuity. The commission has also tried to justify the extension of the term of the panel. As noted above, the time period of 1 year specified in Rule 21 for destruction of the OMR sheets coincides with the time period specified for validity of the panel. There is no doubt that the counseling process and appointments made to the post of assistant teachers 9, 10, 11, 12 were made after expiry of panel. This is illegal and contrary to the rules. So why the Supreme Court has taken the pain to say in respect of 9, 10? Because there was no BAC committee. BAC committee was only for Group C and Group D. And 9, 10, because at that relevant point of time, Lokhi Tunda was the first matter. Second matter was Sabina Yasmin. No, Shetapuddin is 9, 10. So at that Lokhi Tunda was the first matter where Group D appointments were cancelled by the Honorable Justice Gangobadhyay. Thereafter came, my lord, the 9, 10. Thereafter Group C. Thereafter last 11, 12. So therefore, the Supreme Court took up, my lord, the pains to, my lord, say that this is illegal and contrary to the rules. Reliance on the orders / judgments of the High Court in stray cases of rank jumping where the High Court directed to appoint candidates after expiry of the validity of panel would not have any significant impact because these persons were also there before the Honorable Supreme Court, the expiry panel candidates. They tried to substantiate their appointments saying that, look, we have been appointed pursuant to the orders passed by the Honorable Court. The Honorable Justice Gangobadhyay had also passed many others. Division bench had passed, saying that, look, there is a COVID situation and all these things. But those orders were taken care of by this line, saying that the court at that stage was not concerned and aware of the illegalities in the appointment procedure and had not specifically examined the question of appointment after expiry of panel. So full stop. So nothing after this. All subsequent orders, everything taken care of, and the Honorable Supreme Court holds that this is illegal. Now, with regard to why these persons, these names of expiry panel is not being published as tainted. There is also a division bench judgment. It is being sought to be distinguished before a lordship that illegality and tainted are not, my lord, similar things. In my humble submission, there is nothing remains where Honorable Supreme Court has said it is tainted, and because of these proceedings, because I'll show the BAC committee also before a lordship, the judgment passed by the Honorable Justice, Honorable Division Bench, presided over by Honorable Justice Subrata Talukdar, that what were the illegalities committed, how it was committed, it is there in the BAC committee report. So therefore, there cannot be anything which can be, my lord, tried to substantiate that these persons are not tainted persons and their names will not be included in the list of the tainted candidates. This argument was also made by me when I was challenging the list of purported tainted candidates in respect of 9, 10, 11, 12. Now, my lord, this was moved by me before the Honorable Justice previous, I'll not take all names, before the coordinate bench, where the coordinate bench was of the view first, saying that why you have not come up after the 17th April order, because 17th April order said that only the untainted teachers will continue. First question put to me was that why this delay? Why you have come up after the publication of the list? And that was the point which was taken by the Honorable single judge to dismiss. And second point which was there was that the Honorable Supreme Court at that relevant point of time was in session of this matter.
So these were the 2 points. It was taken up by the Honorable Division Bench. The Honorable Division Bench was of the view that since the Supreme Court is insisting of the matter, so therefore this cannot be decided. Obviously, to be the some SLPs were carried up, and those were dismissed. So therefore, I'm trying to, by saying this, I'm trying to distinguish the situation which prevailed when I had challenged the teachers list, and the situation which is now, as the Honorable Supreme Court has passed an order in Paria, Vivek Paria, saying that everything will be scrutinized by the Honorable Single Judge. So therefore, I am now before your Lordship with regard to, because obviously the commission will come up and say that the same arguments were made, and in respect of the teachers panel, it is recorded. I have annexed those judgment also. It was recorded specifically paragraph 31 that my contention was that expiry panel should be included, sorry, other way around. So these will not be relevant as of today in view of the fact that now everything is being determined and decided by the Honorable Your Lordships. So now, my lord, now kindly comes to the celebrated paragraphs. Paragraph 45, 46, 47. Lordship may not trouble, my lord. By now, again, it is by heart. The last question, which relates to relief and whether it requires any modification, we find no valid ground or reason to interfere with the direction of the High Court that the service of the tainted candidates were appointed must be terminated, and they should be required to refund any salary stroke payment received. Since their appointments were the result of fraud, this amounts to cheating. Therefore, we see no justification to alter this direction. Which direction? 663, subparagraph 4. So, the Honorable Supreme Court in this has treated 663 subparagraph 4, those 3 categories to be tainted candidates. This is my contention. Now, this has now again been reiterated by the Honorable Division Bench. Not, my lord. Paragraph 6 is for the not specifically found to be tainted. My contention is that I fall in this category, paragraph 46. For candidates not specifically found to be tainted, because in paragraph 363, 4, OMR mismatch is not there. Only the OMR blank OMRs are. And how many blank OMRs, that also I'll show. For the candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void due to the egregious violations and irregularities which violates Article 1416. As such, the appointments of these candidates are cancelled. However, candidates who are already employed must not be asked to refund or rescind any payment made to them. However, their services will be terminated. Further, no candidate can be appointed once their intent examination process is declared void. Now, my lord, while referring to this, again, paragraph 363 comes, persons who have been directed to refund the salaries. Now, kindly comes to division bench.
Page number 167.
Yes. Kindly takes up volume 2, the thinner volume. In the file, it is there. Thinner, next, yes, that is the volume. The judgment starts from valid coordinate benches.
Sanjay Doloi.
Sanjay Kumar Doloi. This has also been placed. I am placing paragraph 31, 32, 167. Yes. Paragraph 31, I am not, my lord, reiterating because this is quote unquote of paragraph 363. Paragraph 32. Paragraph 363(4) has classified 3 categories of candidates who can be described as tainted candidates. This is the classification done by the division bench. In Supreme Court, it is there. Interpretation is there by the division bench. This interpretation is not there any elsewhere. Persons who have been tainted outside panel, persons tainted after expiry of panel, and persons who have submitted blank OMR should to obtain appointments. We do not fall within this category, so therefore we are not tainted. Now, I'll be showing your lordship's kind, I'll be drawing your lordship's kind attention to the CBI affidavit. My lord, may I come back after the lunch recess?
Yes.
Well, because
No, today is Thursday, application day, so it cannot be taken up. After recess, it cannot be done.
Tomorrow?
Tomorrow will be difficult. I'll place it thereafter.
tomorrow is because one of the points that I'll be placing before your lordship, I'll be praying in respect of teachers matters. Your lordship has been pleased to direct the production of list of persons who have been appointed after expiry of pen. I'll be praying the same in respect of non-teaching staff, group C and D. I'll be trying to substantiate to your lordship the time, because in the Supreme Court, in the compilation, they have disclosed the dates of the my lord counseling. Just a minute. Supreme Court 11,000 পাতার কম্পাইলেশনটা রাহুলের কাছে আছে। এসএসসি মেইনটা কোথায় গেল? আছে সবই আছে। Yes, primary SSC. Yes. Just a minute, madam.
Commission, tell me one thing. The disclaimer that you all have published, is it only in respect of the teachers?
The selection which is going on, second
Yes, I have.
Non-teaching is coming in.
Non-teaching.
This is
going on. Put up a disclaimer also. Maybe, you never know how
and
long
12th is the last date for filling up the application, tomorrow.
The application stage.
Yes, whether they will be entitled to fill up.
No. Not. In the notification itself, I have annexed the notification. They have said
you cannot.
I cannot. That is my challenge, because this is for the first time I have come to know that my names have been construed to be tainted.
No, but then this panel was there long back.
No, that is my contention. This is for the first time. We have come to know that after Supreme Court order, we are being construed as tainted candidates. After publication, lordship kindly comes to the notification once.
That order may be passed tomorrow, because I'll have
page 173.
Kindly seize page.
Volume 2, page 173.
I cannot appear. That is volume 1, page 173. Because why I have said about the teachers is that teachers knew that they might not be, my lord. I'll just place, lordship may not open, page 173. This is the notification dated 9th October 2025, where it has been said, it is clarified that candidates who have been identified as tainted in terms of the judgment dated such and such will not be eligible to apply. And thereafter, my lord, on the same day, the impugned list has been published. So therefore, I cannot. So the interim order that I have prayed before the Honorable Court is that we should be allowed to participate, subject to whatever outcome. If we do not, if we are losing in this writ petition, our candidature will be cancelled. But if this we lose this 12th,
if interim order is passed in your favor, then this is going to create havoc.
This 3512 candidates will be able to appear.
Just see the volume of candidates who will slip in if the permission is granted to you to appear.
Subject, if your lordship is of the view that it is not there.
Interim order cannot be given.
Second interim order that I'll be praying is that for production of the names of the persons who have been who have been appointed post expiry of the panel in
That is
respect of Group
different.
C, Group D, and the dates are, Lordship, this is the the document which was there in the Honorable Supreme
Doesn't
Court.
matter. I will not take soft copies. Whatever is there.
So they should produce in respect, as your Lordship has directed. The Lordship is considering expiry panel in respect of teachers on the same thing on 6th. Let these also be placed on 6th, as Mr. Dhar will also get the chance to say, because if my argument,
Because he is arguing in the
teachers matters, he is not arguing, but the principle is the same. So principle is the same. So he might have something to say with regard to my submissions also. So everyone, it will be basically not that I'm trying to take a march and of his absence. So that is why I'm saying on 6th, the names of the teachers who have been appointed after expiry of the panel is there. I don't know whether the third counseling name has been given. Rahul will be, Mr. Singh will be able to say, or Mr. Bandyopadhyay, he's also there.
Yes, after third counseling.
After third counseling, because third counseling was within the validity that they are saying, but the counseling had taken place after the expiry of the panel. The notice was within the validity. The notice was, just a minute.
You say that the notice was published within the validity period, but the counseling actually took
Yes,
place
yes,
after it.
yes. That is the notice. That is the notice. I have taken the note. Just a minute. Publication is on in respect of group D, group C. Publication of 11-12 was on 27/11/2017, and in respect of 9-10 it was in March 2018, 12th March 2018. The third counseling notice was published on 8th March 2019. So just one day
After.
Oh no, before 8, 9, 10, 11, 12, 4 days before. And the counseling took place on 19/3/2019, 23/2019 in respect of 11-12, and 9-10 would be 26th, 27th, 28th, 29th March and 1st April 2019. Dates are there if your Lordship wants. What I'm contemplating is that out of this, my lord, the juniors will take the responsibility, not him also, and my juniors, if your Lordship directs, compilation of just the relevant documents with regard to the counseling places, the notices of counseling, the dates of counseling, so that Lordship doesn't have to go through these voluminous things. This
You
difficult.
can always prepare. Where is the difficulty?
I'll then just the counseling notice. But in respect of Group C, Group D, the counseling notices are not there. There were no counseling notices. Only the dates would be appearing from the compilation which they had filed in the
How
Honorable
did the candidate get to know?
I think they were intimated by my lord SMSs and
SMSs on
emails, because the SMSs and emails were there in the application form itself. This is auto-generated now. As we book a gas, it comes, SMSs comes. I think there was some kind of.
So there was no independent communication. No independent communication to the candidate.
I have not come across. I may subject to correction of the commission. My lord, I will if that has come to, my lord, if it is that is the query, if that has come to the query, my lord, I will again go through the entire documents and come up. And but today, my lord, I would be praying these two interim order. First interim order, Lordship has, my lord,
It cannot be granted.
second, if your Lordship now can.
Lordship is not heard of.
No.
Your Lordship would kindly, bear in mind, if your Lordship is proposing to pass any order,
The first interim order that has been
participation and everything.
no.
Abide by also, my lord.
No, this cannot be done. The second,
Then Lordship may kindly
put it up in a cover as you've done in the teaching staff matter. Non-teaching will same thing.
Passed, because this issue is perhaps covered. What he is seeking to raise is perhaps covered. We have some submissions. May the matter be heard tomorrow. I'll make submissions, and thereafter your Lordship will pass that.
Did you publish that list?
No, we have not, done anything, without your lot today.
No, this is the query of the court. Then this is what the petitioner is
In
praying.
if I have correctly understood
Candidates.
your lordship, your lordship wants whether any rider or whether anything has been published in the website.
No. That is the disclaimer. I'm not telling about that. Right now, what the petitioner is saying is the candidates appointed after the expiry of the panel in the teaching staff matter you have produced before the court yesterday. This you can do it here. This you can do.
I'll come back. Kindly don't pass the order today. Kindly
If
allow
your
them to
lordship
take
is not allowing us to participate, they are
tomorrow.
দাঁড়াও না বলছি তো তুমি সবসময় ভাবো কেন? If your lordship is not allowing us to participate, lordship may hear them and pass because this সবসময় ভাবো জানো
Submission. No, had submission made on behalf of the petitioners whose name appears.
One. If your lordship is not inclined to grant us, then no orders may be passed. Express rejection is not required.
I'm not rejecting.
Yes.
Acha.
She's posting the matter tomorrow.
Yes,
তাই সেটা বলে
I'm
দিচ্ছি সেটাই
posting it
বলে
because this should be on record.
Yes.
Tomorrow.
যে যাও
Whose names appears in the list of tainted candidates published by the commission.
আমার বাড়ি কি হয় আমি কিছু জানি না, I don't know.
So, as the name of the petitioners are enlisted in the list of tainted candidates,
allegedly
they cannot participate in the recruitment process of non-teaching staff within bracket clerk and group D.
Allegedly.
In terms of the notification dated 9th October 2025 published by the commission. Stop. The petitioners are aggrieved by the publication of their name in the list of tainted candidates. Stop. Specific submission is that the petitioners cannot be treated as tainted ones. Stop. The issue has to be decided. Stop. List the matter for further consideration on 7th January 2026.
Others matters are in 6th, I think.
If all comes on the same day, it will
And
be
my lord,
difficult.
production of the list.
And it is sure that within one day it cannot be over, right?
No,
The
nothing.
respondents
Process
have
is
not
going.
even started their submission, so it is going to take time. So this
And
is
production of the list, my lord, that
production, let it remain, because since you all are not being allowed to participate.
Of course, on instruction.
well, lordship if kindly records one line. If subsequently, if I'm not there, the orders will be there.
I cannot.
Lordship will be deciding the production issue on the next date. Kindly records one.
All right. Prayer has been made to direct the commission to publish the list
Production.
of candidates.
Production.
The production couldn't publish na production of the list of candidates in the group C and D category.
এই যে এইটা দিয়েছে এই দেখো এইটা দিয়েছে
permitted to appear for counseling and appointed after the expiry of the panel.
Instruction is no one was appointed in group C and group D after expiry of time.
All right.
Oh.
Is on instruction.
All right. The issue will be considered on the next day.
Deep
widen the road, making any acquisition. Now they're saying we are not concerned. Concerned authority is the original state rural agency. I'll show, my lord, they are also enrolled there. I just show you.
Who are you representing?
My lord, I'm representing the alleged contender number 2. My lord, taking a cue from the submissions made by my learned senior friend that they're the owner of a plot of land.
No, no,
My lord, only
merits will come later on.
my
Who
lord.
are you representing? I want to know.
My lord, the alleged contender number 2 being the executive officer of the concerned Jela Purishad, that is district magistrate. I'm representing. My lord.
I am for the respondent number 3, contender number 1.
My lord, there is no.
Show the report.
Oh, my lord.
Yes, ma'am.
One.
One.
My lord, what my lord will say, applicant, my lord, I on the petition said, the land original owner is one Khoitan company. They sold out some my vendors. They sold out all these are with me. My lord, but my land was not recorded in my name. But when I approached them, they did not take any steps. I came before Honorable High Court. Your Lordship kindly come to page 15. Your Lordship order. Specific order is that, my lord. My 12, my lord. In the event private land is required for the purpose of widening and construction, then steps shall be taken to acquire the same in accordance with law. Well, this is your lordship's crux of the basic order. So they did not appear. Then, my lord, I wrote to them order at page 17, my lord.
Was the state agency, rural agency party in?
No, it's not a party. But how they are involved, I just show you, lordship. I submit your lordship. You also kindly, my lordship is to serve is correct, but I show how they are interlinked. I tried my best, my lord. And kindly come to page 17, my lord. So I served the copy of the order of the Shavadipati, executive officer, engineer, on 16 May 2025. Now, your lordship kindly come to my learned friend's affidavit. This is by the controller 2. If you also can come to
yes.
His case is that very simple case is that this construction was done by West Bengal Rural Development Agency under PMGI scheme. So the independent authority, we are not concerned with this construction. So we have not committed any contempt. This is the basic contention. Now, if you also kindly come to page my lord, kindly come to page 6, my lord. It's a letter from additional executive officer Alipurduar Jila Parishad to the my lord.
WBSRDA.
Yes, SRDA. I see the second paragraph. Actual matter as appears had been originated over the issue of construction, rather upgradation of existing road to road, Joteshwar Gram Panchayat area and Falakata. The petitioners had objection over road over a few plots, naming as this. Princeton Road, as it reviewed, has been undertaken by the WBSRDA, Alipurduar Division, not by the Alipurduar Jila Parishad. So, the order dated 30th April passed by the Honorable High Court is not applicable to the actual project implementing authority. You also can consider both the authorities are there. They said because to the executive engineer of that rural development authorities, he said the additional executive officer said this order was not applicable to them. I'll show them how they are interlinked, I'll show. He got the order, he got the writ petition, everything. Then he said that, am I clear? Said that he advised to the executive engineer, that agency, that no, this order is not applicable to you. I see the date is 16 May 2025. So additional executive officer is a ADM, my lord. He was not the party, but DM is a party executive officer. Next, logically come to page 7. Despite that executive engineer of that agency wrote to the, maybe the contractor wrote to the, in continuation to WP number letter of that executive engineer, that additional executive officer was given. In continuation to the subject and reference as mentioned above, the Honorable High Court has ruled out, but I don't know what's the meaning of the ruled out, that in the event private land is required for the purpose of widening and construction, then steps shall be taken to acquire the same in accordance with law. Hence, following the direction of the court, no any construction activity will take place in disputed stretch of the road under construction at Judicial Block PMG until the matter is resolved from both ends. This is letter of 22nd July 2025. Now, my lord, while come to the contempt, my lord.
I see a field inquiry report also thereafter. What does this say?
I'm coming. I'm coming. This here. I'm coming. Yes, this they admitted. Then I just come, my lord. But can you see where I file the contempt? This is letter in my page 18 on 4th July. They made the construction. My specific amendment in paragraph page 18 and page 19 of my paragraph 15A. At page 11.
11 of the contempt?
Yes. Page 11. Paragraph 15A. I said that the CB machine has been deployed on 4th July 5 from removing the structures from widening and construction of the middle road by encroaching the portion of the aforesaid plot of land. Petition on asking the agency which executed work has told that.
I have followed it. You tell me, what does this site inspection inquiry?
Yes, I'm grateful, my lord.
Show me that it has actually been utilized for the
Yes.
purpose of widening the road.
They admitted, my lord. You will also kindly come to page 9. My lord, they said the kind of number use of private land without acquisition. Has got it, my lord. The physical verification of the measurement indicate that private lands has been used by road expansion construction activity. This includes plot number 11. My 56 is mine, 1021 is mine, 115 is mine, 106 is mine, 107 is mine, and 108 is mine. That is my in the petition also I have said. I have given a chart. You also can see without seeing the report I have given in my page 9 that these plots of land, my lord, is mine. They themselves that they acquired it without acquisition. The road was constructed, they admitted it. Now, my lord, what my learned friend said that this is independent agency, a rule does not say this. Just so. Rules. But this is the scheme has been. I just regarding PMG, kindly come to clause 1.2. The page 1, my lord. The PMG employees bottom, my lord, can see the list of roads to be taken up each area. Is got it, my lord? 1.2 at page 1.
Yes.
And this 1.2 can see the PMGS employs a bottom-up approach project planning and preparation. The core network from which the roads to improve are selected is prepared by block level in consultation with the concerned panchayats and constituted at the district level. The list of road is to be taken up. Each yearly allocation is first prepared by the PU, approved by the Jila Position. So they can't say that they are not, they are involved there. Can you see first? Second, can we come to my lord, can we come to internal page 6, A.3. This is very A.3. The broad principles of laid down the PMG guideline. No fund to be provided under PMG by land acquisition. Land acquisition can be done by the state government, but in its own cost. Responsibility of the state government, district panchayat to ensure land availability for taking up the proposed road works. So they are involved. Next one you also can come to.
এটা কত ক্লজ দেখালে
A.3.
A.3
Can you come to page internal page 9, my lord? (4.1) Information on the salient features of finalized PMG roads under the core network will be disseminated to the public. The information will be displayed at the notice board of the Jila Parishad and the concerned Gram Panchayat. The information to be displayed shall include map. So this is their Jila Parishad. Then my lord, can come to my lord, in page 12, 4.6. After finalizing the technical drawings, the road alignment, the PU Gram Panchayat will organize a formal consultation with all those persons likely to get affected. So next, your lordship can come. That page 15, internal 15. For the execution of civil works contracts or project, the state will acquire or make available on a timely basis land and rights in land, free from all encumbrance. No selection of part thereof under the civil works contract shall be handed over to contract unless the applicable provisions of the CPF have been complied with. So here's the state involved. Now you also can come to internal base 21. Six point 3.2. District level Jila Parishad. Display code network at the Jila Parishad, the Gram Panchayat office. Disseminate project information to project affected community in coordination with the PU. Ensure establishment of land management committee. So this is their Jila Parishad's function. Now my lord, can come to is.
All right, I have got it. I have got
my
What is
submission.
your submission.
My lord, kindly appreciate this. My learned senior friend has indicated that they are the owner of a plot of
About
land.
ownership.
Now, my lord, kindly seize your lordship's order. That is at page 16. The operative part, paragraph 11, paragraph 12, my lord.
Yes.
In view of the above, the instant writ petition is disposed of by directing that it will be opened to the Alipurduar Jila Parishad to take steps for widening and construction of the road in accordance with law. In the event private land is required for the purpose of widening and construction, then steps shall be taken to acquire the same in accordance with law. So, my lord, subject to correction, acquisition, requisition, acquisition, payment of compensation is related. Why I say so is with the owner of the land. Now, my lord, kindly sees only one averment in the application for contempt. Paragraph 5. Page 7,
I will
paragraph.
not go into ownership at all.
Then, my lord, kindly
Your
appreciate.
report
Yes.
mentions that the land of he may not be the owner. He
He is
claims
in
to be
possession, and
right?
he is operating a hut
What
in
hut
that
is
land, my lord.
The land has been utilized for the purpose of widening the road.
My lord.
Why will the legal procedure not be followed?
My lord, that will be followed. There is an inclination. My lord, my learned friend, senior friend has already indicated from the report that how there is an inclination to comply with your lordship's order. Lordship kindly sees this document annexed with the report. What the event, my lord, they are not a party. WBSRDA says what? My lord, kindly sees page 7.
Not to take up the work
Yes.
till it is resolved.
Till it is resolved.
Then it has already been done.
No, my lord, this is the, my lord, kindly sees the report from the revenue officer.
Yes.
My lord, use of private land without acquisition, clause 3, page 9.
Yes.
It is not the case of the writ petitioners that they are in possession of the entire area where the, yes.
Who is in possession is not important. Important is you in the sense
Yes.
state. Not
Yes.
only a particular Jila Parishad, WPSRDA.
My lord.
It's a state.
My lord.
Using somebody's private land
My lord.
for public purpose.
My lord. So, my lord, in a disputed portion in respect of which the petitioner raised dispute, on that portion the construction work has been stopped.
Stop?
Yes, my lord, that is indicated in the report also. The communication made by SRDA. That is what my learned senior friend has referred. My lord, can you see again page 7?
That was done or that was not done.
Hence, following the directives of the court, page 7, second paragraph.
Yes.
No any construction activity will take place in the disputed stretch. That is the
made this construction has been made.
no, my lord. That is why the construction has been made in a portion in which there is a no dispute. My lord, kindly sees why I refer to page 10, the ground report. My lord, kindly sees.
I just answer one minute.
1 minute.
My lord, page 10, clause 5, possession and local use.
Page 9.
My lord,
Page 9.
my lord,
One.
page 9.
One is very
3. 3.
One is, can you see?
My lord, the physical verification and measurement
Yes.
indicate that private land has been used for road
Has been used for that means
My
it
lord.
has been used already.
So, my lordship kindly sees your lordship's order. Lordship, there is no such direction that the concerned authority should stop construction work. My lord, the observation and the direction made by your lordship that construction work may go, but may continue, but compensation has to be paid. For that, landowners has to be identified. That's why there is a report from the revenue officer. Lordship kindly sees page 10 once. Why I say so? Land record status. As per land records, the concerned plots are recorded in the name of Kothari Plantation and Industry Limited. The representative of claims that these plots were through a registered sale deed and they are right. However, the undersigned did not bid. Now, my lord, the possession. Local testimonials confirm that the land is not in exclusive possession of Shiva Uddog. Several local people, shopkeepers and vendors have been occupying the area for an extended period.
He
Subject
says
to
that there is a
correction.
hunt
Yes,
going on.
yes. Again, my lord, I repeat, subject to correction. The portion in respect of which the writ petitioners have dispute, the construction work has been stopped. My lord, the law will take its own course. The identification of the landowners, acquisition, requisition, and the compensation will be paid. But my lord, the intention of the writ petitioner, if I am getting it correctly, to stop the construction work and widening in respect of the entire land. Probably that is not the direction from your lordship,
But then
and
this
that is
submission
not
was not
reflected.
made by the petitioner even once. Why are you taking up the submission of the petitioner?
My lord, I am not
The
taking, but
petitioner has not
my lord,
submitted.
the entire land is not in possession of the writ petitioners even. So, my lord, what I get from the above means the construction.
Well, I just
No.
sorry, my lord.
It
Till
cannot
time
be
one
done.
paragraph is completed. I'm paying, my lord, I'm paying leave, my lord.
Petitioner, yes, the petitioner claims to be in possession of certain plots of land over which
Percy, may I say one thing? Percy,
road widening
may I say
has
one
been
thing?
done.
May I say one thing? So entire issue can be effectively adjudicated if the West Bengal West Bengal Rural Development Agency is made party in the entire scenario, because they are the implementing agency and the competent person to answer the the core of the list of the present list. Now, my humble submission is that since the Jela Parishad and my client is not the competent authority to answering respondent, so this may I believe that
I have
this
followed your submission. Please wait. Has been done. Step from the report. Now, from the affidavit of compliance filed by the executive officer of the Alipurduar Jila Parishad and district magistrate Alipurduar. He is the DM.
My lord, executive officer of the Jila Parishad is the district magistrate.
It appears that an inquiry was conducted to ascertain as to whether private land was used for widening of the road without acquisition. Achha, for widening and construction of the road. Stop. The report of the revenue inspector, comma, Joteshwar -Roman 2 Falakata dated 1st August 2025 clearly mentions that physical verification and measurement indicate that private land has been used for road expansion and construction activities. Stop. LR plot numbers of the land used for construction have been mentioned therein. Stop. The plot numbers which the petitioner claims to be occupying are indicated in the report of the revenue inspector. Paragraph. Specific submission of the petitioners is that the construction work started after the order was passed by the court, amounting to contempt. Stop. Paragraph. Learned advocate representing the contemners submits that from the affidavit that has been filed, it is apparent that the petitioners are not the owners of the subject plot of land. Step. They may be in possession of the same, but there is no proof as such. Step. Next. It has been submitted that direction of the court was passed upon the Jila Parishad, whereas the construction work has been done by the WBSRDA, West Bengal State Rural Development Agency. Stop. The Jila Parishad was nowhere responsible for the construction, and accordingly, the officers of the Jila Parishad cannot be hauled up for contempt. Stop. Paragraph. Learned counsel for the petitioner has relied on the Rural Roads Sector 2 investment program prepared by the West Bengal State Rural Development Agency for the Asian Development Bank. Stop. Portions of the said planning document has been placed before the court, wherefrom it appears that the Jila Parishad or the state cannot shrug off their responsibility in case private land is being used for public purpose. Stop. There is a provision for formal consultation with the affected persons, which appears not to have been done by the authority. Stop. Had the consultation process been conducted, then the objections could have been raised in proper time. Stop. The contemners contend that the dispute that no construction has been made over the disputed plots of land. Stop. The aforesaid contention possibly cannot be held to be proper in view of the categoric statement made by the revenue inspector disclosing the plot numbers over which construction has been made. Next. As the executive engineer of the Jila Parishad happens to be the district magistrate of the district, and the acquisition and the acquiring body will be the collector, accordingly the executive officer being the no, accordingly the district magistrate Alipurduar being the ex officio executive officer of the Jela Parishad is directed to take all necessary steps in accordance with law as the private land has been used for public purpose. Stop. The authority is not required to enter into disputed questions of title or ownership, but the authority shall ensure that proper compensation is paid to the appropriate person in accordance with law. Stop. Hearing of the contempt application stands deferred till 19th of February 2026. Stop. A further affidavit by the executive officer Alipurduar Jela Parishad and the district magistrate Alipurduar shall be placed before the court on the adjourned date, disclosing the subsequent steps taken in the matter to comply the direction passed by the court.
Only one subject. Whether your lordship has directed the officer, the district magistrate or the executive officer will not go into the question of title. But subject to correction, my lord, the notice has to be served for acquisition to the title.
Recorded owner.
Yes, my lord.
Sir, who's stopping you?
My lord, can it be a, my lord, since it's a, my lord, this process may take some time, can it be, my lord,
A little bit later on?
subject to correction? 19th of March, if it's commensurate.
19th of March.
Lordship, in this matter, I am appearing for the alleged contempt number 2. There was a direction to file report in the form of affidavit. It has already been filed in the department, Lordship. Yesterday, I have filed it in the department. It was affirmed on 26th of November.
Did you serve copy upon the petitioner?
So service has not been made, Lordship. If the petitioner provides the email ID, I can serve it through email, Lordship.
Yesterday, I personally made telephone to my learned friend, and he
Yes,
assured that
thereafter in the evening, I had called him to know the email ID, but unfortunately, he
kindly have a
was
look, madam. Only
busy.
one
He could.
My lord, my learned friend's client only killing the time. But she took time for fulfillment of the part of the private respondents. What happened, my lord?
For
my lord, only for the fulfillment, the purpose of the private respondents. My lord, what happened, my lord? Only
No,
two
these are
pictures I want to
baseless
show.
allegations, Lordship.
2 or 3 pictures I want to show, your lordship. But this is, my lord, your lordship give direction not to fill up the PWD land. They have admitted that this is the PW land encroached by the private respondent by encroaching my egress and ingress in my residential house, for which your lordship give direction not to take steps. Earlier direction was not to take any steps. Therefore, after filing the contempt application, your lordship was pleased to give direction not to take any steps. Now, this I have handed over lastly the earlier photographs. This was the situation of the side land. Now, after filing the contempt application and receiving the copy of this contempt application, this is the latest picture. What they have done. Now, the Pradhan in any.
Your submission is that this is the PWD land?
Yes. They have also admitted this is the PWD land in their report.
They have admitted?
Yes.
What steps have the authorities taken?
Nothing.
PWD land you are permitted occupying by the
private respondent.
Lordship, as per the direction of your Lordship, the Pradhan of the Gram Panchayat had gone to the land, and she, with the BLLRO, made an inspection. The land of the PWD is not occupied by the private respondent, Lordship. It is other land, Lordship. The land which has been acquired, occupied by the private respondent is a separate land, Lordship. As per
Not
the report of the
PWD land. Not
Lordship.
PWD land.
Lordship, the PWD land is the separate land. It is a separate DAG number and
Tell me whether the PWD land has been occupied by
no,
private
Lordship.
person.
No,
I
Lordship.
recorded my learned friend submission and let them file affidavit.
That is my
Affidavit has
instruction.
been filed, you collect it. Give a copy to your learned friend.
Lordship, by in the course of the day, I will
Here,
kindly,
recorded my lord, that no PWD land has been acquired.
Lordship, kindly instruct my learned friend to give his email ID, Lordship. I will.
Yes, Mr. Bikash Singho, who are you appearing for?
Lordship, I appear for contempt number 1, Lordship.
Who is
Lordship,
he?
Lordship, PWD officer, Lordship.
What is your
Assistant
submission?
engineer,
Has your
Lordship.
land been encroached?
No, Lordship, land is the Gram Panchayat land, Lordship. Kindly see the order, Lordship, page number 20, Lordship. I have submitted one report, Lordship. It appears that rights of in respect of the subject land stands in the name of Gram Panchayat, Lordship. And Lordship, the contempt number 1 already comply the order, Lordship.
Land belongs to the PWD land, government land. Let my lord issue rule, my lord. Otherwise, the Pradhan will not take any appropriate steps.
Already order has been complied, Lordship.
কি বললাম?
And in the main writ petition, the Pradhan was not a party.
Learned advocate representing the petitioner submits that report. Now, that affidavit of compliance has not been served upon him. Stop. Learned advocate representing the contender number 2 submits that the affidavit of compliance has been filed
Yes, that
before the circuit bench at Jalpaiguri.
Yes.
Stop. Let a copy of the affidavit of compliance be served upon the learned advocate representing the petitioner. Stop. According to the contemners, the PWD land has not been encroached upon by the private respondent. Stop. The aforesaid contention is denied by the learned advocate representing the petitioner. Stop. Paragraph. It will be open for the petitioner to file an exception to the affidavit of compliance filed by the contender number 2. Stop. Let a copy of the affidavit of compliance by the contender number 2 be tagged with the file. এখানে কি আছে? Contender number 2 এর affidavit কি আছে?
Lordship, may Lordship, contempt number 1 has already been complied, Lordship. Kindly dispense with Lordship. He is already complied.
No.
The order, Lordship.
Definitely file exception.
You take all these back.
I have already, Lordship, I have already filed the complaint report, Lordship, and I have served through
It is
WhatsApp
already
mode.
recorded. আচ্ছা, released আসেনি না? Let it be tagged. Directionটা থাকবে. And list the matter on 12th of February. 2026.
Grateful.
In the middle, can you give my learned friend directed to serve copy of the affidavit?
Yes, he'll serve.
Lordship, kindly date the direct email ID, Lordship. Provide the email ID.
You know his phone number, you pass on your email ID and he'll serve copy.
Yes,
Deeply observed. Deeply observed, Lordship.
Lord, I am for the petitioner, my lord.
Has the order been complied?
My lord, the order has been complied to the effect that, my lord, if your lordship kindly sees the order of affidavit of compliance, my lord, this land has been recorded as JOL. That has been confirmed by the BLRO. I have made RTI application. The record of right stands Jol as on date also, my lord.
Which district?
My lord, Purvo Mednipur.
Ah,
My lord, they have encroached upon, they have, my lord, filled up this pond. Thereafter constructed.
All in Purvo Mednipur doesn't mean the water body.
No, my lord, that is, my lord, Jola Jomi.
Yes, it is
But
mentioned.
my lord, kindly sees the, my lord, kindly sees, my lord, what has been done at the instance of the private respondent. And my lord, this sanction plan has also been sanctioned by the Pradhan illegally, my lord. Kindly sees, my lord, when the sanction plan has been sanctioned and my lord, the construction has been made. There has been a contention that the...
Is this a houseboat type of thing or what? It's not. I can see over the water body, stilts have been constructed over there. The house is being constructed. What is it? 68 I'll see. These are the pictures. I'll hear you. I'm only seeing the pictures that have been placed.
There's a plan in 2021.
I'll hear you.
My lord, kindly comes to the, my lord, plan, my lord, affidavit of compliance, my lord.
Yes.
My lord, page 60, my lord. My lord, the contention of the Pradhan is that the ground floor has been constructed long ago, when she has no idea, when there is no sanction plan with respect to the ground floor. But in respect of the first floor, the sanction plan has been given on, my lord, kindly see page 60, my lord, bottom portion. My lord, plot number 132, this is signed on 26th of November 2021. My lord, this civil case was pending. There was an injunction order. My lord, I have annexed that in the writ petition also, my lord. There, still date, my lord, there is an injunction order in respect of this plot number. Then also this sanction plan was sanctioned. Thereafter, my lord, construction has been made. Secondly, my lord, kindly comes, my lord, to page 67. My lord, page 67, my lord, it is an application before the appropriate forum for conversion of the land from Jol to Bastu. Only application has been made. That has been annexed to this affidavit of compliance. There is no conversion as on date. RTI, or kindly sees the RTI report of the BLR concerned. My lord, this is the reply of the BLR. Till date, no conversion has been made. But the sanction plan has been approved by the Pradhan in respect of Jol.
Yes.
And my lord, kindly comes to the order passed by the Pradhan, my lord. It starts from page 93, my lord. Relevant portion at page 94. My lord, second paragraph, from the records and inspection report, it is seen that the ground floor of the building has been erected long back. However, Sheikh Sanu Ali did not take any permission for constructing the house, but SK Salahuddin has taken permission for renovation and construction of the first floor. And the construction, and there is a sanction plan, being sanction plan number, no one knows, my lord. And the inspection report says there are adequate space kept open in the said land, as the total land is measuring 0.4 decimal. Though, my lord, in the record of right, this in total 132 plot number consists of, my lord, 16 decimals of land, within which, my lord, I am the owner of 3 decimals of land. Petitioner is the owner of 3 decimals of the land. They are the co-owners, my lord. I am not disputing that. But thereafter, my lord, kindly sees in the said land, as the total land is measuring 4 decimals, only building plan has been constructed in 1.72 decimal of the land. But the total area of the land, my lord, where the construction has been made, that is 2.5 decimal, my lord. And there is no statutory space kept open. That is, your lordship can see the photographs, my lord. It is over the, it's like a houseboat, as your lordship indicated, my lord.
Yes.
Now, let the also kindly see that the initial allegation of the petitioner was that there is the building plan, without the building plan, the house has been constructed. We also directed the Panchayat to cause an inspection, inquiry, and then pass a reasoned order. Now, not subject to kind sanction, if you would kindly take page 56 for a second. That's the application filed by them. That's it. For the purpose of sanction plan. So after the sanction plan was, the application was received. So thereafter, an inquiry was made. Along with that, he has filed certain documents. Also, we kindly take one after one document. In the application at page 56, where he disposes his
details and Lord, the description of the land in the bottom. But he wanted to construct a house in 1.72 decimal. Now, Lord, thereafter, Lord, he says in paragraph 58.
First of all, the land is a water body.
I come to that. They have filed a document indicating that they have applied for sanction of the Lord should kindly take Lord page 16.
Yes.
The page 68 is a document which was filed along with the application for Lord sanction plan. That too Lord in the year 2021. Lord, based on these document, Lord, the after inspection, Lord, since Lord there are specified rules, Lord, which says that he should keep Lord vacant space for Lord in fourth side of the thing.
For what? Swimming purpose?
The difficulties, Lord, based on these documents, the office has not told Lord how it functions.
Then
Based on these documents,
what is to be done?
Sanction, Lord, has been given, Lord.
How can you do it?
Indeed, Lord, subject to sanction, Lord, this was, I'd say, Lord, inadvertent.
Inadvertent. What will be the consequence?
To Lordship, Lord, but we cannot.
Go demolish it.
Lordship would kindly give us some time, Lord, we'll take care. Never the intention of the Pradhan was to Lord disobey your Lordship's observation and Lord, we'll take care of that.
What were you doing so long? You'll take care of that?
Difficulty is, Lord, on the last day, Lord, I explained for your Lordship, Lord, that they were not being guided properly. The moment, Lord, even Lord, after issuance of rules.
I do not know whether you know about the photograph that is being shown. I'll show it to you. This is the photograph. Isn't this a houseboat type of thing? Huh?
The Lordship knows that ponds are integrated part of the house, but I still check.
You see
I'll still check.
pillars, and over there you made construction? And the Pradhan has gone to grant permission?
And my lord, from the very inception, my lord, we have made repeated representations, went before the Panchayat office, but no steps taken.
Just see this photograph covered by water all four sides.
I can see, Lord, I'll not see it again. But at the time of Lord discussion, Lord, I was given on a different idea about Lord the building where has been constructed. So, Lord, I'll take care of that.
Who has given you the different idea? The instructing lawyer. Is he also involved in this unauthorized construction and illegal procurement of plans?
But I was given the impression that Lord, it has been constructed because the ground floor structure for a longer period.
The ground floor doesn't have a sanction. You go and sanction the first floor. Something which doesn't have a base, you go on to make high rise over there. Please come.
My lord, the Pradhan is so adamant, my lord. On the last occasion, your lordship, my lord, your lordship directed the Pradhan to submit rupees 5,000 as cost. Thereafter, my petitioner has been, my lord, debarred to participate in any village proceeding. He has been debarred to enter the
Has the
masjid.
cost been paid?
Masjid, yes, my lord.
Where?
Masjid also.
I've annexed the receipt.
He has been banned from the village. He cannot enter the masjid also, my. This is the conduct of the Pradhan without complying.
What is the allegation?
No, I'll take care of that. I'll definitely take care. That should not have been, but I'll take it.
Please.
No, I know your lordship's view, Lord.
Exactly. Please make your client clear.
That is the reason that I jumped in and I wanted to secure your lord's compliance of your lordship's order. But this part, Lord, which my learned friend is alleging, but I have also seen.
What does the contempt Pradhan do? Does she do anything?
No, she's a lady, Lord. She's
No. A lady doesn't mean that she will not do anything.
She doesn't do it. No.
She doesn't do anything. Where from does he get all this of impetus? Who is giving her all these things? The courage to disobey the court's order, to ban somebody, to resist somebody from...
I can take instruction here, but you should also kindly allow me for a second.
দেখুন তো was she required to be present today?
Yes, your lordship asked her.
All right.
The difficulty, she was also ill for some time, and she has underwent operation twice, and I also read the medical document. I know your lordship on the last question also pointed out, Lord.
The Pradhan of the Gram Panchayat, being the contemner, is personally present in court. Stop. Affidavit of compliance has been filed by the contemner. Stop. It is evident therefrom that the subject construction has been made absolutely contrary to the rules. Stop. The Pradhan permitted construction to be made over water body. Stop. There is no permission permitting conversion of the classification of the plot of land from water body to Bastu. Stop. The reasoned order of the Panchayat signed by the Pradhan on 10th January 2025 clearly mentions that the ground floor of the structure was constructed without taking any permission from the Panchayat. Stop. Despite noticing that there is no sanction for the ground floor, the Pradhan went on to issue sanction for construction of the first floor.
He also paid for sanction of the ground floor. It's
Next.
ground floor and first floor both. Lordship would kindly take
The documents have been annexed to the writ petition and affidavit of compliance in support of the submission that post facto approval of plan for construction in the ground floor. What no?
in the plan, Lord, the Lordship page 20 in 2021. The
Yes.
application they have prayed for sanction of both the floors. The Lordship would kindly
No,
take.
but the construction was made prior thereto.
Yes.
That means post facto approval. Last
For both the floors.
last week or possibly in the early portion of this week, Supreme Court passed orders where post facto approval of sanction plans cannot be done.
Yes.
Affidavit of compliance in support of the submission that post facto approval of plan for construction in the ground floor
Was sought for. Stop. The learned advocate for the petitioner has produced photographs before the court. Produced photographs of the subject construction before the court. Stop. It is evident that the construction has been made by constructing pillars over the water body. Stop. The same is out and out illegal. Stop. The learned advocate representing the contemner submits that steps will be taken to deal with the unauthorized construction that has been made. Stop. Next. In view of such submission, hearing of the contempt application stands adjourned till 12th February 2026. Stop. Steps taken by the Panchayat to deal with the unauthorized construction shall be placed before the court on the adjourned date. Stop. Learned advocate of the petitioner has drawn attention of the court to the fact that the Pradhan is threatening the petitioner and has debarred him from participating in any social programs. Stop. Though such allegation is denied by the Pradhan who is personally present in court, but the Pradhan is cautioned not to take up any steps contrary to law. Stop. In the event the petitioner feels threatened, it will be open for him to approach the officer in charge of the which police station?
Moina police station.
Moina police station. Who, on receipt of a complaint, shall take immediate steps. The photographs be retained. Yes, please do. Photographs be retained with the record. Yes, the personal appearance of the contemptor stands dispensed with until further orders.
Grateful, Your
একটু চেক করে নেবেন তো।
Well, 155 to 59, I am appearing for the petition.
Well, I am appealing on behalf of the municipality, leading Mrs. Suma Chaudhary, madam.
My lord, yesterday, my lord, your petitioner received this PPO, my lord. That PPO was issued wrongly.
Wrong date?
Yes, my lord.
You have to get it corrected.
No, my lord, kindly turn left-hand side, 4th line, my lord.
Yes.
First date of entry into approved service, my lord.
2000.
2000, no, my lord.
It should be prior there too.
No, my lord, kindly see your lordship's order, my lord.
Ah.
Please, contemptor. My lord, kindly see your lordship's order, my lord. First 2 line, my lord. 13th December 1995, my lord.
Which page? Order date?
First, appointed
service,
yes, 10th October. First 2 line, my lord, 13 December.
That was your submission.
Not, my lord.
Yes.
Not only that, my lord. First page, last paragraph. Kindly see, my lord, your petitioner relies upon the memo number.
I understand this.
My lord, on the basis.
Matter also last occasion.
That is Gaulia municipality. That is Gaulia municipality. That is the question of approval. My lord, this matter is not approved, deemed approved. That matter, my lord, kindly remember, my lord, Swapon Chatterjee's case, my lord, going to the Supreme Court. Next matter, my lord.
No, you first complete this, then we'll go to the next matter.
Yes. My lord, this
where is your...
Kindly see this memo, my lord. Your lordship already stated, my lord, this memo.
Where is the memo?
Yes. Possibly, my lord, the memo have already lying with your read file, my lord.
Yes. 1988. Tell me the memo number you tell. 1988.
Serial number 7.
Serial number 7.
Yes.
Radhapodo.
No. And এটা দিন শশাঙ্ক শেখর কর্মকার এটা ওরা আমাকে দেবেন হ্যাঁ
Where is this memo? Is it annexed anywhere?
Not annexed, my lord. At the time of hearing, my lord, it was handed over to your lordship.
Shashanko Shekhar Karmokar, date of engagement is 1995. All right. This is Boidwati municipality.
Boidwati municipality.
Yes, madam. I am for appealing on the Boidwati municipality, madam.
There is a signature of the chairman of the Boidwati municipality mentioning that 13th December 95 is the date of engagement of the petitioner.
Well, they are initially appointed on the unapproved staff in the municipality. As per sanction, PPO has been issued by the DPP chief, mother. After verified all these things, mother, they have issued a pension payment order. We have to carry out that said pension payment order, mother. On the basis of that, now the entire process is going on. Day before yesterday, we have received the PPO order, and already we have made an ad hoc payment also, mother. They have received the 2 lakh rupees and further
No,
payments it
ad
is
hoc
under
payment.
process.
It is from 2000. You are calculating 5 years benefit. Why will the employee lose? There is no
Well,
reason.
the operative portion of the order, my lord, did not say that he has to be given effect to with effect from such and such. It's a fresh cause of action, my lord.
It is just my lord. Kindly see this order, my lord, passed by Lordship, my lord. Earlier matter, my lord. It is in Joseph. It is in. My lord, kindly see this order, my lord.
Without sanction. The post of sanction that from the date of the
Yes.
and was the approval also granted from the date of petitioner was appointed without sanction. When the approval was granted and the post was sanctioned, that is from 2000. That's what the municipality.
My lord, my lord, earlier occasion, my lord, that another matter, kindly see this order passed by Lordship, my lord, same PPO was issued, my lord, wrongly. Thereafter, your Lordship passed the order and rectified the same. And all the advocates are also same, my lord. Vasudev Laha. গুলিয়ে ফেলো না কাগজগুলো কই? Thereafter, my lord, rectified the same.
Rectified?
Yes. Kindly see next order, my lord. It has been just
Mr. Panda was
if you already annexed, my lord,
order,
I have already
Vasudev
annexed
Laha.
with the order.
See, it is the same thing.
All the advocates are same.
My lord, the DPPG and
Last page,
DADLB
my
has
lord,
sanctioned
PPO
these things, my lord.
এই গুলিয়ে ধরা
The director of local
Lordship,
bodies
here,
will.
Lordship. Lordship, I am
Yes, Mr.
appearing on both
Busho,
the.
your submission is in the other matter is also recorded.
Yes, all are
And your client has complied the court's order. Ashunto, it has been brought to the notice of the court that the e-pension payment order has been issued in favor of the petitioner on 9th December 2025. But the first date of entry has been incorrectly recorded as 1st February 2000. Stop. The petitioner relies upon the list prepared by the chairman of the Boidubati municipality, clearly mentioning that the date of engagement of the petitioner is 13th December 1995. Stop. The petitioner prays for giving benefit to him on and from the first date of engagement. Stop. Paragraph learned advocate for the petitioner relies on the order dated 7th November 2024, passed in CPAN 673 of 2023 in WPA 13849 of 2021 in the matter of Vasudev Laha versus Pintu Mahato and others, wherein similar mistake cropped up at the time of issuance of the pension payment order. Stop. Upon direction from the court, the said error was rectified. Stop. Fresh PPO was issued mentioning the correct date.
But here, Lordship, kindly correct the municipality, Lordship. I am the I am not a pension sanction authority.
Yes.
Lordship.
Paragraph. It appears that in the matter of Vasudev Laha within bracket Supra, the court directed the municipality to correct its own records and give benefit to the petitioner on and from the date of appointment as mentioned in the Communication dated 20th November 2017. Stop. Next. The similar order is being passed herein. Stop. The municipality ought to correct its own records and proceed with the matter with the Director of Local Bodies and the Directorate of Pension, Provident Fund and Group Insurance for correction of the first date of entry of the petitioner in service. Stop. It appears that the contemners corrected the date of first entry in service in the matter of Basudev Laha within bracket Supra. Stop. The municipality shall do the needful and ensure that its records are corrected and the petitioner is treated in the same manner as that of Basudev Laha within bracket Supra. Stop. The matter stands adjourned till 26th of February 2026.
My lord, one submission on behalf of the municipality, my lord.
Krishna,
Municipality will correct,
revised
my lord, no
pension
doubt
payment
about
order
it. But the
shall be issued
DPP and DLB
in
should
favor
cooperate
of
in
the
respect of.
petitioner prior to the
Brother,
adjourned date.
DPP and DLB should correct these things, my lord.
একটা করে দিচ্ছি
All same?
না 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 ডেট আলাদা আছে দাঁড়ান না
Date.
মালাট নেক্সট ম্যাটার মালাট
Next matter.
এটা দিন তাহলে হবে
Let
নেক্সট
me see.
ম্যাটার মালাট ডেট অফ ইনিশিয়াল অ্যাপয়েন্টমেন্ট 1st February 1991
Shondip De.
সন্দীপ দে 1st February 1991 মালাট and PPO মালাট 1st February 2000 with
Yes.
effect.
ওখানে একটা
Next,
95 সালে
next,
একটা
my
date
lord.
বলেছিলাম না 95
এটা মাধব এই পয়েন্টটা দেখি ঢুকিয়ে দাও হয়ে যাবে নেক্সট মাইলট
এটা হবে এখানে এই যে 1 ফেব্রুয়ারি 1991 আমি এখানে লিখে দিলাম
এটা দিন দাঁড়া এটা অর্ডার হচ্ছে কোনটা এটা আমাকে দিন হ্যাঁ এই
This is Shondip.
সন্দীপ
Next.
মাইলট ইরানি
হ্যাঁ, ইরানি দাস
এটা দিন
দেখি
ইরানি দাস মাইলট ডেট অফ ইনিশিয়াল অ্যাপয়েন্টমেন্ট February 2, 1991 February 2, 1991 মাইলট and PPO মাইলট 1st February 2000
all right
কেন ইরানিতে রাখো এটা
এই পার্টির নাম এখানে
ওটা না ওটা না
আর
ওটা এই
95টা এটা চেঞ্জ হতে থাকছে
ওটা দাও
ঠিক আছে yes next
বিশ্বনাথ সিং মাইলট
ইরানির ফাইল কোথায়
এই ইরানির ফাইলটা
ও
ইরানি দেশের ফাইলটা দিন
ইরানির ফাইল কোথায় now is Vishwanath
Singh
হ্যাঁ
April 2, 1991 initial data paper
দেখি এই ফাইলটা সরান
বিশ্বনাথ সিং
এটাকে সরান ওটা এর নয় বোধহয় এটা কার এটা ইরানির না এটা হচ্ছে বিশ্বনাথের
বিশ্বনাথ সিং মেলাট April 2, 1991
2nd April 1991
Vishwanath Singh Malat
and
Malat this PPO was issued 1st January 1997
whatever
দিয়েছেন এটা
yes
বিশ্বনাথ সিং দিয়েছেন ঠিক আছে থ্যাংক ইউ ছেড়ে দিন ওটা হয়ে গেল নেক্সট মালাট এতে বলো নেক্সট মালাট হরিসাধন কর্মকার লাস্ট দাম দিচ্ছি হরিসাধন কর্মকার মালাট ইনিশিয়াল ডেট অফ অ্যাপয়েন্টমেন্ট February 1, 1991 and PPO টা
ওইটা দিন তো ওইটা দিন
কথা বলা ভুলে যাচ্ছে
ঠিক আছে।
হরিসাধন, February 1, 1991, my lord. Initial date of appointment. And this PPO is on 1st February 2000. My lord, and another, my lord, on last occasion, this matter, Horisadan Kormokar, my lord, cost title of the order, my lord. There are some mistake, my lord. Vishwanath Singh versus Pintu Mahato, my lord. But kindly see the last order passed by your lordship, my lord, that cost title.
First title I can see Horishadan Kormokar.
Horisadan Kormokar.
18th of September 25.
Just wait. September 25, my lord.
It is written Horishadan Kormokar.
My lord, my copy is Vishwanath Singh, my lord.
How can that
One copy. Vishwanath Singh versus state of হ্যাঁ সব ঠিক আছে কেস নাম্বার ঠিক আছে জাস্ট নামটা ভুল হয়েছে
No, but then here the proper order is there. Let me see.
এই কপিটা দিন
The case number?
সেম all are same there are আবার কপি কি করে ভুল হলো ওটা
It has been brought to the notice of the court that the cause title of CPAN 803 of 2024 has been wrongly is being wrongly reflected in the server. আচ্ছা অর্ডারের ডেটটা দিন 18/9/25
এটা আলাদা বাদুর
কি দিয়ে শুরু করলাম of the court recorded in the order dated 18th September 2025 বলে ওটা দিয়ে দেবেন ঠিক আছে হ্যাঁ from the records it appears that the name of the petitioner has been correctly recorded in the order sheet stuff. The department is directed to take necessary steps for uploading the proper order sheet of the order dated 18th September 2025. তাহলেই হয়ে যাবে তো
দিন ওই অর্ডারটা আমাকে দিন
yes
I'm grateful to that
No, all the matter I am appearing on for the director of pension and provident.
yes
I am grateful.
DPPG
But I am happy on behalf of the municipality in all my matters.
yes
দর্শক দেওয়া হয়েছে তো I'm grateful এই যে ওকে দাও না আমার এসেছে তো
I cannot hear you, madam. Is it working? Green light is blinking. Let me see what you've got to say.
Lordship, item number 160. I am the petitioner.
Yes, what is the matter?
Lordship, on last occasion, my lord, Lordship pass some direction upon them to comply.
What is the violation of the court's order?
Lordship,
Are you not ready?
Lordship,
File is not here.
I'll let my be another side in that side.
All right. I'll make it not today.
Lordship, make it not today.
Not today.
Last order, my lord. There has been no partner development.
Hearing officer still not appointed?
Appointed, my lord.
Appointed?
Yes, ma'am.
When?
He was appointed on 25th of September 2025. And now he's taking up matters. Lordship grants us some time on the even last today it is submitted no steps. But pursuant to my lord's observation at page 16 6 paragraph 6, the hearing officer has been appointed, Now he's taking up issues matters.
Please come.
It is lying with the Jela Parishad, my lord, so far as the second
It has
is
been
concerned.
brought to the notice of the court by the learned advocate representing the state that hearing officer has been appointed and steps will be taken to comply the direction passed by the court. Stop. In view of such submission, hearing of the contempt application stands adjourned till 19th of February 2026. Stop. An affidavit of compliance shall be prepared and circulated prior to the adjourned date.
Very grateful.
And so far as the demolition order of your lordship is concerned, basing on the fact according to the submission that there is a demolition order, there is no demolition order.
Let it be.
Therefore, your lordship
Hearing officer,
consideration of the
Everything will
hearing officer will consider.
Right.
As your lordship. We have made a supplementary affidavit disclosing the document in support of our sanction plan. Our sanction plan that was raised by them.
Place all these documents before
They have
the
placed
hearing.
before your lordship. Sanction plan is not there. They have given consent to the conversion even. They have given a consent.
Wait, you place all documents. Next.
Lord 162, my lord. Lord, I am for the petitioner, my lord. Your lordship kindly see the order dated 11th of September, September 2025. Your last order, my lord.
Page 18.
Paragraph number 3, my lord, your lordship kindly see. Order, paragraph number 3 of the order.
Yes.
My lord, they have done nothing.
I am showing what I have done. He will always say. Page 19.
Every day my learned friend is staging drama. Every day. Your lordship kindly see. Apni bosun chup kore, please. They have nothing, my lord. They have done nothing. As it is. As it was.
All right. Yes, please show what you have done.
I am page 19, my lord, your lordship's order first. আপনি কিছু বলবেন না কিন্তু যতক্ষণ আমি বলবো কিছু বলবেন না তারপরে আপনি বলুন
Yes.
Page 19. As it appears, your lordship's order, that the representation of the petitioner objecting to the illegal unauthorized consent is pending consideration at the end of the respondent authority, no useful purpose will be served by keeping the writ petition pending. The writ petition is accordingly disposed of by directing the respondent number 3, being the commissioner so-and-so or his delegate, to consider and dispose of the representation made by the petitioner strictly in accordance with law, after giving an opportunity of all the to all the necessary parties, including the petitioner.
Yes, what has happened?
Now, madam, I am saying. This is my report, and this is then I am placing up. This is the proof.
Pass on copies to him also. Yes.
I'm sorry. Firstly, my lord, goes to the report. My lord, so cause notice so and so, hearing not attended so and so, as per order so and so attended, reasoned order passed so and so.
Your report.
My lord, report.
I have seen all.
So demolition has been done.
It suggests.
No, I am saying.
Your report suggests no demolition has been done.
I am saying. Partial demolition so and so, vacate notice again, partial demolition again done. Next page, my lord, next page. I have again asked them to fix a demolition date. That is being already
so
fixed.
What he's saying is correct, that you've not done anything, and the photograph suggests you've not done anything.
If your lordship so directs, I will. আমি বলি যতক্ষণ
municipality has no intention to demolish the lot.
All right.
Municipality has some interest.
All right. What will you do? You have the bulldozers to go and bring it down.
My lord, if your lordships want to implement your lordship's order, my lord, then necessary action will be taken.
Yes.
It is up to your lordship.
No, I'll grant you liberty. If you have bulldozers, go and bring it down.
I will not.
You will not.
I bow down your lordships, my lord. Only I am praying before your lordships to direct my learned friend to demolish the
What is the court doing here? Not giving direction.
My lord, your lordships have definitely giving direction, my lord, but they have not implementing.
Yes. So what is to be done? What is to be done?
My lord, I pray before your lordships, my lord, to give some direction so that they can compare to implement your lordship's order, my lord.
All right.
My learned senior brother is satisfied. I will call any of the building engineers. I think he will be satisfied for that.
Why?
Because if your lordship so directs, he will say.
What will the building engineer do?
My lord,
If it is unauthorized and you have
I will demolish that. I can say before your lordship, my lord will fix it any date. Already commissioner and the chairman has already transferred. Chairman has resigned. So my lord, fact is this.
Who is there in charge?
No charges at present. Already.
And
only the engineer
submit that the order will be complied.
It will be complied.
It can never be complied.
I will be complied.
Who is going to comply? Tell me.
The executive engineer and everyone is there, man. They will comply with.
Executive engineer?
Everyone is there. If your lordship.
The assistant engineer in charge?
Yes, he is also there. And the demolition squad engineer, main engineer, he is also there. If your lordship directs, I will call him. But fact is this.
It's not a matter of calling.
No,
I'm going to stop their salary.
No, only what?
No.
No, only what?
Enough.
My lord, may I say?
This was your show cause is of the year 2017. We are entering 2026.
No, order is passed on 23.
Doesn't matter.
My lord, only one thing, my lord.
No.
I'm only saying, let it last chance be given.
No last.
My lord, if you also give me a last chance, I will come with a compliance report any day. And what happened, my lord? In the adjacent buildings are also there. Adjacent buildings are there. So required measures are taken.
From the submission made on behalf of the petitioner, the corporation, it appears that the unauthorized construction has not been demolished.
That is their concern. I can come with a photograph in the next week also.
The report of the assistant engineer in charge building department signed on 11th December 2025 clearly records that show cause notice
that
was issued
6 years before the order
on 23rd July 2017. The order of the court was passed in the year 2023. Notice to vacate the unauthorized portions was issued on 23rd April 2024. Demolition work was fixed on 26th July 2024, but demolition could not be done due to non-vacating of the building.
No, demolition has been done, madam.
The further inspection was done on 13th August 2024 and partial demolition done on 7th March 25 and 11th August 25. Further notice to vacate dated 21st August 25 to the parties was issued and partial demolition again done on 8th September 2025. Further date of demolition is fixed on 23rd December 2025 onwards. The photograph of the unauthorized construction has been placed before this court. It appears that no demolition.
That is their photograph. I cannot bring any photograph.
The intention of the authority to deal with the unauthorized construction is very apparent from the report placed before the court. The unauthorized construction, which was detected way back in the year 2017, has not been brought down even by the end of the year 2025. If the department acts in such a lackadaisical attitude to deal with the unauthorized constructions, then the authority will never be able to bring down such construction, as there will always be resistance from the occupiers of the said unauthorized construction. In this manner, an unauthorized construction remains standing for years together. Such cannot be permitted to be done. Next. Under such circumstances, the court is compelled to direct stoppage of salary
That may be
of the
a warning may be given.
executive engineer, building department,
He is going to
comma,
retire around
the-
last December, madam.
the assistant engineer in charge of the building department and the executive engineer of the demolition squad of the Howrah Municipal Corporation. Till a report is placed before this court to show that demolition did actually take place of the unauthorized construction. Stop. The contempt application is directed to appear in the list on 12th of March 2026.
That will be very far because they will.
Yes, you mentioned. I will prepone it, but it has to be mentioned by you.
Yeah, grateful, my lord. At least a focus may be given, otherwise, then they can.
163. Yes.
Item number 163. On the last occasion, my lord.
And on the last occasion, I filed the affidavit of compliance.
But
And municipal, we have already paid the entire gratuity in respect of area pension. Municipality has forwarded the sent to the director of local bodies for arrangement of fund. Due to paucity of fund, municipality is unable to pay. And on the last occasion, your lordship recorded that affidavit of compliance file, and it will open to the municipality to arrange the fund for releasing the terminal benefits. But my lord, we are praying for 2 months time to release the area pension.
Very well. Your salary will be stopped.
My lord,
till you
already we
release
have
the
already
payment.
paid the intergratuity. We have already forwarded on the last occasion. Your lordship
Enough
recorded.
is enough
Keep
with
the
y'all.
my lord, due to municipality due to paucity of fund, municipality has already forwarded 5th April of the said municipality to the director of local bodies. This is the
Please come.
appropriate authority. And no response has been received from the director of local body. And we have sent a reminder.
The
5th April.
order of the court dated 18th October 2023 has not been complied with till date.
Partly compliant, my lord. We have already paid gratuity, entire gratuity.
The petitioner is the widow of a retired employee of Purulia municipality. He expired on 31st August 2017.
Yeah.
No, sorry. He retired on 31st August 2017, but did not receive his terminal dues prior to his death on 3rd June 2018. The widow is running from pillar to post to realize the terminal dues of her deceased husband. Stop. The learned advocate representing the contemner / municipality submits that due to want of funds, the due cannot be released. Stop. The part payment of the gratuity has been made.
We have paid already entire gratuity, madam.
As a partner, entire gratuity amount has
your
been
lordship
paid.
recorded on the last occasion.
All right. Stop. The
And we have sent a reminder to 5th April 2025 to the director of local bodies to arrange for fund. Total claim 73 lakhs 87,640.
Acha. The the director of local bodies is not a party in the
Yes, madam. Director of local bodies is the authority. And on the last occasion, I filed the affidavit of compliance.
You have not complied and you have filed your
Oh,
affidavit of
my lord, I've filed the affidavit. We have already sent a reminder to the director of local bodies to arrange the fund in respect of area of pension, total claim 73,87,000.
Yes.
Yes, my lord.
So what will happen? You go on sending letters. Will that help the petitioner?
Director of local bodies in municipal department of municipal affairs is the appropriate authority. So we're praying for 2 months' time.
What will you do in 2 months? Again, you'll
We have already
seek
know
adjournment.
as a last chance we am praying for.
Can you assure that the director will pay the money to you? You cannot assure.
We will undertake to
What
comply the order
undertaking?
because you also on the last occasion recorded it will be open to the municipal to arrange the fund, my lord. We have already sent a letter on 5th April and total claim. I say that the total sum of rupees 73,87,643 only was accounted for towards area of pension. But my letter dated 5th April.
লিখুন তো যে as the municipality, for the reasons best known, has failed to clear the terminal dues of the deceased employee, no further lenience can be shown to the municipality. Stop. Next. The court, under such circumstances, is compelled to direct stoppage of salary of the finance officer and the executive officer of the Purulia municipality until further orders. Stop. The matter is made returnable on 12th March 2026. Stop. An affidavit of compliance shall be filed on the adjourned date. As a learned advocate for the petitioner is directed to communicate this order to the aforesaid authorities.
Item number 163 to 175, all of them.
But then 163, the widow has come. 164, who has come? The employee. Employee. When did he retire? When did the employee retire? আচ্ছা লিখুন তো। The petitioner retired from service on 31st May 2021 and till date has not received his terminal dues. Stop. Enough opportunity was granted to the municipality to pay off the dues of the retired employee. Stop. The municipality claims to be suffering from acute financial crunch. Stop. The submission of the municipality cannot be accepted. Stop. The order of the court was passed long back and the terminal dues ought to have been released by now. Stop. Acha, order of the court was passed nearly 2 years back. Yes, under circumstances, we stoppage of salary ta thakbe.
And my lord, intergratuity has been paid, my lord.
All right, whatever you've paid. Next, পরপর ডাকুন তো। এখানে ডেট অফ রিটায়ারমেন্ট হচ্ছে 31st October 2022. Next,
Same matter. Yes.
166. একত্রিশে মার্চ 21। Yes. এটা রিটায়ারমেন্ট হচ্ছে 30শে এপ্রিল 22। Give your appearance and not anybody who's not there. All right, it's only you. What is your name? All right, Devayan Ghoshan naam deben. So what? The proceedings are live streamed. You should understand. Somebody who's not here and maybe somewhere else, how can the person remain present? Had the council appeared virtually also, I could have recorded. But somebody who's not there cannot be done. Acha, date of retirement hoche 30th June 2020. Next. November 2019.
না
Next.
টাইম যথেষ্ট দিয়েছে, আর নেই।
28th February 2022. Next.
কত পর্যন্ত আছে?
31st October 2022. Thirtieth June 2023. 30শে June. একত্রিশে July 23। তিরিশে November 21। একত্রিশে October 19।
My lord, I am paying for 170. I am paying for short passover.
On behalf of whom?
I am led by Pampa Dedhaval.
Page 16 is the impugn order.
I am for the petitioner.
Yes. Has it been complied?
My lord, I will kindly come to the order, my lord. Illegal construction was, my lord, alleged of. Your lordship directed the SDO concerned to hear and, my lord, pass a reason order. Pursuant thereto, my lord will find a reason order has been passed, my lord, on, my lord, 5th August 2024. After hearing the petitioner.
Yes. Then?
Well, it has also been served.
What remains?
Nothing remains, my lord, subject to correction by your lordship, my lord. Your lordship did not go into the merits of the matter. Your lordship directed the SDO concerned to decide the issue. Now,
This
SDO
is the order of the SDO I can see.
My lord. And my lord's order, directions at page 17, my lord will see.
Yes, 5th of August 24.
My lord.
This
The
is
petition
the
is disposed of.
SDO's
Order.
Since the plinth and height and where obtains action was
subsequent to the, my lord, the petitioner as on date has a sanctioned plan.
What, that is different.
Right.
Whether
No,
he has, he doesn't.
I did not want it to press on merits, my lord. I only said.
Where is your senior?
She is on the way.
All right, let her come. I'm passing it to her.
Pass, short pass.
They can
Yes, on the way.
I appear for the petition in this matter, not pursuant to the order passed by your lordship.
My lord, in this matter, I appear contempt number 3, my lord.
Contempt
Lord, there.
application has been served with the contempt respondents. All the respondents, they have received it. Page 24 is your lordship's order. That has been violated.
They have not done anything. They have not done anything.
Now the revenue officer along with the panchayat officer fixed a date for holding inspection of the building where it is situated. The contempt respondent prevented the officers to hold any inspection, resulting which inspection could not be held. I served a notice upon the authority, all the authorities, to held the inspection in terms of in compliance with your lordship's order. Even then, no steps has yet been taken by the authorities.
My lord, no such direction against the contempt number 3, my lord. My lord, kindly see the order, page 24.
You are the contemptor number 3.
Yes.
Who are the others?
Well, other the Gram Panchayat, my lord, there is the order of the specific your direction, your lordship, my lord.
BLRO and Pradhan, the revenue officer, accompanied by the panchayat authorities, went to the spot to hold the inspection. Contempt respondent number 1 is the persons who prevented the officers to hold inspection to locate where the building is standing. Now, sanction plan has been obtained in respect of plot number 190. Now, he raised the construction over plot number 191 by 359 besides the said building. My complaint was that this building was constructed in versions of the sanction plan, which was sanctioned till plot number 90. But the construction is standing.
How have you served upon the contemptor number 1 and 2?
Yes, by this. It has been received by all the contempt respondents. It has been received, not. The Ranjit Kumar Maiti is the president of the Gwalior Potato Wholesale Vyavasai Samiti. He prevented the officers from holding the inspection to locate where it is standing. And my lord, the notice which was given, page 28, what is concept application?
I am appearing on behalf of the listener one, Ranjit Maiti. I was made party man on this side because your lordship direction to decide the case, Rampodan is directed to me. I have the made a complaint. Well, I was made party. Why I do not know. Total application there is no whisper.
Allegation is that you are resisting the inspection to be done. Why are you resisting the inspection to be done?
But my lord, here your lordship kind of they filed a suit for declaration. That suit was dismissed. Even they did not prepare any appeal. And your lordship was the order.
Why will the court look into the suit? Here, this is an issue of unauthorized construction.
Your lordship, the order of your lordship.
Yes.
Second part. EPTs, your lordship, page 2, my lord. An opportunity of the hearing shall be granted.
Pradeep. None represents the contemptor number 2, Pradhan of the Gram Panchayat. Affidavit of service is on record. Issue contempt rule. Returnable on 12th of February 2026. Affidavit of compliance, affidavit of Pradhan. Yes, next. I am issuing a contempt rule against the Pradhan.
And my lord, the contempt respondent number 1 prevented the officer from holding the inspection. Some steps is to be taken.
It will be taken. Let the Pradhan come and say that the inspection could not be done because of the contemptor number 1. Appropriate steps will be taken.
And in the notice, in my notice, I have stated everything to the every officer, that will be appearing at page 29.
All right. 178.
Well, I appear for the arrest contempt. I'm filing the
Yes.
compliance report.
Right. You've complied.
Yes.
What have you done?
Well, regarding the chain was regarding the chain, first of all, the constated was wrongly, my lord. Some explanation has been given for the delay, but ultimately I have considered, my lord, that it is a colony area. But exactly KMC's drain was not there, but someone, my lord, open drain was being used. Now, in the meantime, the entire area has been, my lord, the KMC drain has been established. Now he has been asked to his house drain to be communicated, the house, well, the waste to be communicated with the main drain. And that was the open, well, they have been closed it. Now it is a defunct drain. Now he has to apply and to make, we have kept it open as and when we'll consider about granting the
Last paragraph, second page, last paragraph, second page, last paragraph. Second page, last.
None appears on behalf of the petitioner. Stop. Learned advocate representing the contemner relies upon the affidavit. No, relies upon
Report.
the compliance report signed by the executive engineer within brackets civil. Boro X 10. KMC. Mentioning that the order of the court has been complied with. Stop. As the petitioner is not represented, the contempt application stands dropped.
But that was the copy, it was signed by the original signature policy is that one. I'm giving it.
এটা ফেরত দিয়ে দিন, ওটা রেখে দিন।
176. 176, my learned friend has done.
My lord, 176 SDO already passed the order as per your lordship direction. My lord, so I have to challenge that order passed by the
176 একটা order record করুন না। The order of the court has been complied with. The petitioner is aggrieved by the manner in which order has been passed by the subdivisional officer. Stop. It will be open for the petitioner to challenge the order of the subdivisional officer before the competent forum in accordance with law. Contempt disposed.
Your Lordship has put if the petitioner is aggrieved, or Your Lordship has quoted that petitioner is aggrieved with the.
No, if the petitioner is
I'm grateful. My lord.
I beg to appear for the petitioner, my lord. My lord, the recent order has been passed, but your lordship's, my lord, order, whether the construction is unauthorized or not, there is no any reflection in this, my lord, order. That is the main fact, my lord. Only for just like a order has been passed.
My lord, we have annexed the photographs and also indicate the disputed portion. Annex the photographs in page number 14. The engineer is showing the disputed area. There is no construction. And also the petitioner already we have done report.
There is no sin.
From 14, how can the court understand whether the construction is legal or not? Where is the order?
Order, my lord, no construction is going on over there.
All right, have you mentioned it anywhere? Recent order, yes.
10, my lord. My lord, it is not going on, but the construction which has already been raised, that has been, my lord, authorized or unauthorized, that is completely silent, my lord. And my lord, at the time of inspection, it is not expected, my lord, the person who is, my lord, going on the.
Please come. An affidavit of compliance has been filed, annexing copy of the order passed by the Pujali municipality, signed by the chairperson on 18th August 2025. Stop. The petitioner is aggrieved by the same. Stop. It will be open for the petitioner to challenge the said order in accordance with law before the competent forum, if so advised. Compliance taken on record, contempt disposed.
My
Mr. Frank, there is affidavit of service. Order is at page number 23. The order has not been complied. To consider the representation,
Not done.
no, Lordship.
Who was to consider? Pradhan?
Pradhan, yes, Lordship.
Issue rule. None appears. It is returnable on the 12th of February 2026.
Grateful, Lordship.
Yes. Service filed. Dismiss for default.
My lord, I am for the petitioner led by Mr. Pankaj Haldar. My lord, there is an unauthorized construction. My lord, please came to page number 19.
The order has not been complied.
No, my lord. We already served. There is
So the
a
service. Rule. Yes. 12th of February. Dismissed. You are there? Yes.
My lord, this is my contempt application, my lord. My lord will find my lord's order which is under contempt at page number 107, my lord. The order under contempt, my lord. On last
Is
occasion,
it
my lord.
15th of April 24?
Yes, my lord. My lord has directed. The direction is actually at page number 109, my lord. Internal page 3. Report file করেছিল? And my lord, on last occasion, the alleged contemners appeared. They filed a report. We have supplementary. We have filed an exception towards it, and my lord, we are also preferred a supplementary affidavit. We have served upon them, my lord.
I do not see any recording over here.
Okay,
Last petition order was passed. Nothing.
They served upon us a report, my lord.
Then that is different. But then
Where is the report? Well, report is in my lord's record. When there is a compliance report they have served.
they were directed to prepare a compliance report and serve, but nothing has been done.
Then, my lord, I would suppose that
under whose back sheet has it come?
It is come in. Actually, the copy which was served upon me is so
Doesn't have a back.
Illegible, my lord. I cannot.
Cannot ascertain.
Tirupati Mukherjee, my lord. It was the learned advocate, my lord, was appearing.
Check up because nobody is here today.
Yes, my lord. I cannot assist your
And
lord also in that matter.
the report is also not here.
Yes, my lord. It will.
So you want your supplementary to be taken on record?
Yes, my lord. Let the supplementary and my lord.
I'll keep the exception also.
Yes,
Please
yes,
come.
my lord.
None appears on behalf of the contemner. Stop. Learned advocate for the petitioner submits that that a report has been served upon the petitioner.
Yes, sir. A report was affirmed on 26 June 2025.
Is it termed as the affidavit of compliance?
Compliance in the form of affidavit, my lord.
As a compliance in the form of affidavit. Compliance in the form of affidavit. was served upon the learned advocate for the petitioner, and the petitioner has prepared an exception to the same. Stop. The exception has been filed in court. The same is taken on record.
And we have served a copy. This is the
All right. The supplementary affidavit prepared by the petitioner is also taken on record. Affidavit of service filed by the petitioner is retained with the records. Stop. Let a notice be served upon the learned advocate representing the contemner, indicating that the matter will be taken up for further consideration on 22nd of January 2026. Take this back.
Mine.
The original compliance in the form of affidavit shall be filed on the adjourned date.
Grateful, Lordship.
184. Yes. Petitioner.
My lord's order, my lord, kindly have a look at page 52.
Not complied.
Partly complied. Hearing was conducted. No reason order has been communicated as yet to me.
Where is the service upon the contemner? Let me see. Degi.
Yes.
In the writ petition also nobody appeared for the municipality.
No.
Rule issued. Returnable on 12th of February against 2 contemners.
Deeply obliged.
Achha. 1 minute. The order was passed upon whom? Municipality. Respondent number 2. Who is the respondent number 2? Why is the writ petition annexed to the contempt? Respondent number, contemptor number 1, rule is issued.
All right, affidavit of service be kept.
Yes, yes. নেব দাঁড়ান একটু ডাকুন একটু ডেকে নিন
Kindly make it not to demand.
No.
Service of there's a direction to service. And we have served tag report is not been kindly not take it. This is the old matter of.
There is a direction for service in April.
Twice service on tag report is not obtained.
Track report is not obtained. Always you have all this type of issues.
Kindly, only making not to.
Not today.
I'm for the petitioner, my lord. I have served. I have served notice. Not compliance and it's lost.
Who is the contemptor?
1, my lord.
Who is he?
OC, officer in charge.
What will the OC do?
My lord, kindly see page 21, my lord. Petitioner made repeating application before the OC, but refused the claim.
What are you doing before the civil court?
Yes. Civil court, my lord, injunction is pending.
Yes.
But no, ensured the police. Last paragraph, my lord, page 21.
To ensure that the order passed by the civil court is complied.
Yes, not complied, my lord.
Why are you not drawing the attention of the civil court that the order is not being complied?
Civil court is case is pending before the title suit, my lord, and injunction is there, my lord. Contender already transferred, my lord. Now, Prashant Pitania at Pigeon.
Then add. Hey, Pradeep, leave to implement the new present incumbent and serve. Come back on the 29th of January. 29th. Affidavit of service. Take this back. এটা ফেরত দিয়ে দিন তো এটা ফেরত যাবে এটা থাকবে first day contempt
Lordship, I appear on behalf of the petitioner, new application.
all right 19th of February returnable serve notice
For the petitioner, first time contempt.
all right serve
190. Returnable on?
আর নেই তো কিছু
97, but I appear for the petitioner.
yes serve